I may mention, I know Lordship does not allow upgrading unless there's an exception.
Yes.
But this is the two advocates matter, Lordship may recall. That is the only exception I can think of. Well, Lordship had heard, and there's continuous.
So, Mr. No, sorry.
Lordship had heard a bit.
We can understand, but no upgrades. It send a wrong message.
For any day for assigned matter, Lordship, like Lordship used to.
That will, we are thinking, mulling over that.
Please do that.
Yes, we are mulling over that.
Lordship, may I be mentioning for contempt matter, my lord?
Yes.
Call.
Your Lordship, may I permit it to?
Yes, one who is appearing.
My lord, one, I beg to appear on behalf of the petitioner, my lord. Here my lord, there are 11 respondents. Actually, I have filed the writ petition in the name of the dead person. Thereafter, my lord, I took the leave from the earlier bench, and my lord, this writ petition has been filed. I have, my lord, registered to all of them, but track report is not my lord.
Why did you have it mentioned? Oh, it came automatically.
Automatically.
Emotion.
And my lord, it is the interesting case that chairman and the member, they did delivered the different judgment. Thereafter, special bench affirming the chairman's
Pick up
judgment.
the matter unless they come.
My lord,
So should you keep it next week?
my lord, we have served through speed post.
But we request track reports and all.
Track reports are not
So we'll keep it after 1 week so that you
after 1 week, my lord.
can, since the respondents have not yet been served, let the matter stand adjourned till September 1, 2025.
My lord.
Thank
Deeply obliged, my lord.
Combined চলে আসছে।
My lord, this is my application. The same prayer, my lord.
Same.
My lord, the respondent I served, my lord. Today I confirm the affidavit service, my lord. Only, my lord, not today.
No, affidavit service, you are ready?
Not, I am ready.
No.
Not yet, my lord.
Copy reached, served.
No,
Copy served.
no. Copy served.
So we can give you leave to file during the course of the day and move the matter now.
Then tomorrow, my lord,
Tomorrow there is no bench, single bench.
Tomorrow's
Friday, huh?
Friday.
Then Friday.
Monday.
On the prayer of the petitioners, let the matter stand adjourned for the day. For the day means Monday.
Lordship.
Ibrahim Sheglet hai.
Item number 3.
Lord, I beg to appear for the petitioner,
I am
appellant petitioner. Your lordship would kindly peruse your lordship's last order, whereby the honorable court has come to a finding that the marriage has irretrievably broken down. My lord, I'll just give a
What is the date of the order, Mr. Banerjee?
last order, my lord.
Our orders are very haphazardly kept. Mediation report is there.
I tell your lordship, my lord, on 2 occasions it was sent for mediation. On the last occasion, the coordinate bench has sent for mediation. There also mediation had failed, and the honorable court had come to a prima facie finding that the marriage has broken down since the parties had last resided as husband and wife
What
for
is
the last 20
date
years.
of that order? Last order.
Well, last order, my lord.
এই অনেক
এগুলো বার করে রাখো না তোমরা।
সাজানো রয়েছে শেষের অর্ডার গুলো উপরে দিন।
My lord,
29/7.
29th of July.
আপনার পেপার বুকটা দিন। আর পেপার বুকটা।
ওনাকে একটু দেখে দিন।
Paragraph 2, my lord, parties are living separately for the last 20 years now.
Challenging what? Your divorce should dismissed.
Yes, I am the husband, suit on the ground of irretrievable breakdown of marriage, desertion and cruelty. Now, my lord, so far as irretrievable breakdown of marriage,
Have you got Justice Sudhanshu Dhulia's judgment?
my lord, I have brought judgment of Justice Khanna, and my lord, irretrievable breakdown of marriage, my lord, it's a facet of cruelty, mental cruelty.
Yes,
And
yes,
my
those judgments were. So, Ms. Mitra, what do you say?
My lord, I have nothing much to say. It's the fact that the parties are living separately since 18, 19 years. And twice the conciliation proceedings have failed. But the fact only remains, if I have at all have to say anything, I only say that the husband petitioner in the matrimonial suit could not prove the allegation against me before the learned trial court. Therefore, the suit was dismissed. Now he has come up for appeal. Other facts, my learned
So
friend.
we can do this, subject to
Yes.
what both of you say. We'll make it an order of the court. No
Yes.
consent, no
But
question of
my
consent.
lord, may I only want my application for the alimony is still pending.
That we have to decide. But then it has to be a permanent alimony.
Yes,
Permanent
we
alimony.
are ready for that.
So we'll give you leave to file permanent alimony application
Yes.
because you have to disclose the assets there also, your
Yes.
assets, and you will give a.
My lord, assets are already on record. On the earlier occasion, we had filed an
application,
affidavit
yes.
of
How long back?
2 years.
Approximately
2
Almost.
years, but I'll give a latest
2
affidavit.
years.
Almost.
I'll give a latest affidavit of this.
You can repeat those. Mostly it will be the same copy paste. But if some new asset has been added or subtracted, then you can reflect that.
Or otherwise, I rely upon the same
Yes.
earlier application.
No,
My
we'll direct you to file a permanent section 25 application.
section 25.
25 applications. So there you can. That was a section 24 basically.
Yes.
So we'll direct you to file. We'll say that if the assets are the same, you can just copy paste and annex in
Yes,
here.
my lord.
But it will be a separate application.
I file a fresh application under section 25.
Yes,
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 my
Ms. Mitra. Now we will just record this that we are just indicating that even if we allow the appeal, we'll say that will not interfere with the appellate court or findings, the trial court's findings, but we will say we take note of the further facts that
Further
they
development.
and
My lord.
grant decree on the ground of irretrievable breakdown. You bring please all the judgments on irretrievable breakdown.
But I have brought.
That's now a good ground. No, now we cannot do that unless we give them an opportunity to file permanent alimony.
So, my lord, it is understood that they are accepting that.
Nothing will be understood. We'll put it on our understanding is not a word. It's alien to both of your clients. Although counselor, obviously, we can see that the counselor is reasonable. Acha. At the outset, learned counsel for the appellant draws the attention of the court to the fact that the attempts at mediation has failed twice between the parties. First of all, learned counsel for the appellant na kore, learned counsel for the parties kore. Twice between the parties. First up, it was also recorded by a coordinate bench in the order dated July 29, 2025, that the parties are living separately for almost 20 years now, which is not denied by learned counsel for either of the parties. First up, next para. As such, it transpires that the marriage, for all practical purposes, is dead, and as such, the agony of the parties ought not to be prolonged. First up, divorce, in such situation can be granted on the ground of irretrievable breakdown itself, which has been held by the Honorable Supreme Court in recent judgments to be a facet of cruelty by both the parties against each other, even without interfering with the findings of the learned trial judge. First up, next para. Be that as it may, since learned senior counsel appearing for the respondent wife points out that the respondent wife seeks alimony, we grant leave to the respondent wife to file an application for permanent alimony, annexing her current assets and liabilities in terms of the judgment in Rajneesh versus Neha. Full stop, next para. Such application shall be filed within a week or fortnight.
2 weeks. 2 weeks.
Within a fortnight, within September 12, 2025. Full stop, reply if any shall be filed. Reply and opposition if any. Affidavit in opposition thereto, along with the affidavit of assets of the husband shall be filed within 1 week.
Within 19.
Within September 19, 2025. Full stop, such affidavit in opposition shall be composite, dealing with both the affidavit of the petition, dealing both with the pleadings made in the permanent alimony application and the affidavit of assets of the wife. Full stop, next para. Reply, if any, shall be filed by composite reply, if any, shall be filed by September 26, 2025. Full stop. The matter be listed on October 27, the reopening day, or any difficulty?
Day after the referendum.
He's much younger, so he may have some difficulty. We'll keep it in the monthly list of November as an application.
As an application.
The permanent alimony application shall be listed next on November 3, 2025 under the appropriate heading. You will file your application along with affidavit of asset. They'll file opposition composite to 26
And
application.
then I will reply.
Yes.
I'm
Reply
ready.
also composite to their assets and opposition.
I'm
Thank you. We have put it on record so that there is no doubt when we take up the next. Yes, Mr. Pan, what is the matter?
No, my lord, my writ application was dismissed on the ground that award has been declared and there is a delay in moving the writ
Award has been?
declared. Now, my lord, award has been declared
This is under what
under
procedure?
the land acquisition 1894. Now, my lord, the fact remains the state used an affidavit wherein a calculation sheet was annexed and treating the calculation sheet as an award, my writ application dismissed. The point in appeal before your lordship is this, that the petitioner, deceased mother, was not served with any order under section 3 because this is a proceeding initiated under the Act 2 of 1948. The West Bengal Land Requisition and Acquisition 1948. So, my lord, without an order for requisition, there cannot be any acquisition. Because first of all, my lord, the requisition is required to be served, which is a mandatory in nature, and thereafter the state can proceed for the purpose of acquiring the land, followed by declaration of award.
Here no notice of
No notice under section 3. Moreover, my lord, no notice inviting me to accept the money in terms of the award. No notice. Moreover, my lord, it is a settled principle of law. If any award is being passed, apportionment of the award is mandatory.
there were how many years of the mother?
My lord, in respect of
Mother
apportionment,
has met her demise now.
my mother has been-
Apportionment between who?
between in respect of the land. Collector has to be the apportionment in respect of the land and in respect of the award itself. There are so many awardees. One has to indicate that what is the share of mine and how much I am entitled to.
All the awards
that
are
is-
related between each other.
No, all the awardees because my lord, this is in respect of the entire area. Now, my lord, what happened? Award is to be declared on a prescribed form, that is form number 13. What they have annexed, that is form number 12, which is a calculation sheet. Under any stretch of imagination, it cannot be said that this is an award. If your lordship kindly see, before I proceed further with this,
My lord, this is an application for injunction. Today, my lord, can't file, my lord. My lord, it was substantially heard by the Honorable, my lord, the other benches. My lord, Justice Arijit Banerjee, subsequently, thereafter, my lord, Justice Tapabrata Chakraborty and my lord, Justice Chatterjee, my lord. My lord, injunction petition was heard, but no interim order was passed. My lord, it is, my lord, your lordship kindly fixed a date for hearing, my lord. The all affidavits are complete.
Today itself we are hearing it, we are taking up the
Today, my lord, I am not ready. Any date, my lord, I am ready, my lord. Otherwise, today, my lord, is come as application. Any date, my lord, your lordship fixed, my lord, I am ready, my lord. I shall do, my lord.
because my lord, injunction was
Injunction is
not
refused, my lord.
granted with the understanding that appeal will be heard out. That's why preparation of
Yes,
paper book done. So
paper books are ready.
yes, all the
Paper
paper
book
books
is
are
ready, my lord.
Learned counsel for both sides apprise the court that the paper books are ready in connection with the appeal. Full stop. Accordingly, let the appeal be listed for hearing along with the connected application on September 2, 2025, next Tuesday.
I shall do.
Bibliog distribution.
Application under section 25 of the Wards and Guardians and Wards Act, my lord, has been rejected, challenging that, my lord, this appeal has
Notice
been.
has been served on the other side.
I served, my lord, Kamalesh Kumar Saha, Kamalesh Chandra Saha has appeared, my lord, entered appearance in the website it is appearing. My lord, may I come back after giving him a
That
notice?
will be better. If
My-
they don't appear still, then we'll hear. Learned counsel for the appellant, comma, on query of court, comma, submits that the respondent is represented by learned advocates. Push up. Accordingly, the learned advocate for the appellant is requested to serve a notice on his counterpart appearing for the respondent, indicating that the matter shall be listed under the same heading on September 2, 2025, Tuesday.
I'm-
On the returnable date, comma, a receipt in that regard shall be filed by the appellant. So that if they don't come also, we can. Yes, Mr. Shanal, what is the matter? You are very excited. What happened? Some papers missing? Or?
Yes, no, paper is not missing. No, brief has not yet come from
Oh.
the car. So
Not
I have
missing,
checked-
it's not there at all.
Huh? I beg your-
Paper is not missing, it's
No, not at all missing, my lord. Because today in the Mayor Road there is a program. I was little late. Chhatra Samavesh like that.
oh.
No, no. So, my lord, your losses can take it up. Item number 7. Both are almost similar. So I have prepared myself in 7.
7 file to আছে কেন? তলাটা। Item number 7 is FMA 950.
Yes, ma'am.
Yes.
Very well. We are taking up that.
No, item number 7 is MAT 743, Majid Khan.
No, it has become FMA 950.
Oh, my lord, my-
FMA number is
Majid Khan is.
Majid Khan.
We are having Majid Khan.
to place like different way.
You are in both the
Sir,
matters
আমার
for
brief
the
নেবেন?
state.
My lord,
For the state or the private?
my lord, I am for the National Highways Authority, my lord.
Oh.
I believe, my lord, I am not the answering respondent, my lord, here. I am only the, my lord, the requiring body. I have already deposited the amount before
Private
the.
respondents, whatever.
My lord, I beg to appear for the writ petitioner. I beg to appear for one of the writ petitioner, Nane Khan and Alom Khan. They have been assailed as respondent number 1 and 2 in this mandamus appeal.
Your writ petition was allowed.
Yes, my writ petition was allowed.
So you are supporting him.
Yes. They are on the same boat. my lord. Now, I wanted to place it in
Not
a
yet
different way, but
Take Mr. Banerjee's brief. And
no, brief not. I wanted to, my lord, not to place the judgment. I was made a wanted to make a request not to go through the judgment first. But I have prepared a tree, but that's missing right now.
So then
That's-
we are compelled to go to the judgment.
That's but because sometimes, my lord, I'm not similar. Sometimes there's one theory: if the judgment part goes to the mind of the division bench, it might be, my lord, influenced by the judgment.
No, but
also.
Mr. Shanal, actually, in an intra-court appeal, that is what it should be in our.
My lord, that's the normal way. That's the
Because
normal
we
way.
are saying this because normal the bias is against interference. Because bias in law, not with
No,
the
no,
mind.
certainly, my lord.
You
That-
know, intra-court appeal, the usual
Yes.
principles.
So let's
But
us
with
go.
the position that we won't interfere. You will have to convince us what is
That's the law.
technically wrong or
Now, my lord, I tell you, lordships, before placing this,
yes.
there is, my lord, this is the acquisition under the National Highways Act. And this is a matter of compensation.
National Highways Act.
My lord,
No, the judgment itself quotes all the provisions.
একটা আনিয়ে নেবেন, হ্যাঁ এখন ওনা দিয়ে দিচ্ছি, ছেড়ে দিন। 2 কপি আনিয়ে নেবেন ন্যাশনাল হাইওয়ে। আছে 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 ওটা ফেরত দিন।
আপনি কি এই শিডিউলটা চাইছেন? টুইটার চাইছেন?
গোলাপি গোলাপি এইরকম কালারের আর গোলাপি তা ফেরত।
Yes, please.
Yes.
Now, your losses will find one provision that section of the Act, section I,
Section?
my lord, just a minute, I'm thinking.
Yes, yes.
এই যে স্যার এটা
This is- my lord, 3H subsection 4. 3H subsection 4. Has got it. Huh?
Right.
Thank you. But just, I mean,
হ্যাঁ ঠিক
if any dispute arises to the apportionment of the amount or any part thereof to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction within the limits of whose jurisdiction the land is situated. My lord, these point, I am frank to your lordship, these point in a specific factual ground came up before consideration before the Honorable Supreme Court. My lord, the Honorable Supreme Court, if I take your lordships, one paragraph has said in the facts of the case. But if we go through, my lord, the entire judgment, one may get an impression that whatsoever may be the dispute, it has to be referred. It's almost mechanical. So, my lord, this is, my lord, a stoic argument always we make. Disputed questions of fact, court should not touch it, go back it. And the learned single judge has exactly done that. He has referred the matter to the competent civil jurisdiction. Why I'm saying it, lordship, that's why I'm trying to.
Then the writ petition was not allowed.
Allowed.
Not allowed.
They wanted that.
They
because they wanted that there is a dispute in regard to apportionment of compensation.
What did they challenge in the writ petition? What was the prayer in the day?
That's the mother apportionment was done.
But they could have directly gone to the civil court then.
No. That the
Apportionment done by whom?
Competent authority.
Ah.
And then they
Without sending it to
they quashed it and send it back to the civil court. The competent authority has no jurisdiction because of this.
So you say that this is not pertaining to apportionment.
My lord, I have twofold, my lord. Apportionment.
If it's apportionment, there is no doubt in this section.
Apportionment
Has to go.
any dispute into apportionment. If there is, my lord, no dispute at all, then what would happen? If the dispute is for the sake of dispute, someone makes it, then what would happen, your lordship? This will mechanically refer to the civil court.
So should we look into the Supreme Court judgment and the
My lord, before that, my lord,
dispute.
I think your lordships kindly have a look at this, my lord. This chart I will give to them. The three of all of them. Notes. If I will stand corrected if I have committed any mistake in regard to this. Or the private response.
they won't be knowing because they're getting
That's
it
your
now.
lordship. No.
Even if you committed a mistake, they won't be knowing because they don't have their clients and they get it for the first
Now,
time.
my lord, kindly have a look at this. Nasrat Ali Khan, original owner,
Yes.
died intestate in 1945.
14 and 15.
Well, there are four legal heirs your lordships will find. Muhammad Khan, Abed Ali Khan, Jamal Banu, and Jahan Bibi. Well, so for Muhammad Khan, son, Naini Khan, and others. Well, I thought it, the others are not because they might raise the same dispute. And Abed Ali Khan, Majid Khan, probably my learned friend is appearing from Majid Khan.
No.
You are from Majid.
Nane Khan.
You are Majid.
And Asma Begum.
Nane Khan bhai in small letters because it's the other side.
I think, my lord, who typed it, like me, my lord.
Yes.
To
And a bias for Majid Khan.
No, my lord, I am very poor in computer. So someone I'm not tech savvy. So my junior, not so much, I feel, like me. Then your losses will find Abed Ali Khan transferred his share to Akbari Bibi in 1960.
Yes.
And so for Jamal Banu and Jahan Bibi, I'm told, my lord, they were issueless or something that your lordships transferred their share in 1948 by Hiba to Muhammad Khan. Muhammad Khan is their brother,
right?
Left hand side.
Yes.
Now, Muhammad Khan sold his share in 1951 to Nasiban Bibi and Sahidan Bibi.
This is only relating to
Two
daughters' share, right?
It devolved upon Muhammad Khan and Muhammad Khan.
Right.
Now, your losses will find, then your losses, there is a suit pursuant to compromise decree in 1966. The property again go.
1 minute will disturb you once, Mr. Shana. In just below Muhammad Khan, you have stated sold his share in 1951, right?
Exactly.
So his share includes his independent share from Nisharat as well as that which you obtained from Jamal and Jahan Bibi. He sold the entire thing, his own as well as those. Very good.
Then what happened?
Khan would have some right.
Exactly. What happened, your losses? Pursuant to compromise degree in 1966, property again came back to Muhammad Khan. They again, malad, compromise degree, they gave it to the Muhammad Khan. Muhammad Khan by gift did, or malad, again hiba, give to his wife Bradun Nesha. Malad, that happened in, let's kindly take one date, 12th October 1992.
73 to give.
Oh, gift is, I'm sorry, gift is 1973, written.
12th October? No.
No, no, no.
1973. That is written.
Ah.
Now, Badrun Nesha wife, after having it by way of hiba, sold it in 12th October 1992. His malad sold in 4 persons. Up to this malad, no dispute between the parties, I think.
All right.
I think if they raise malad, I will stand corrected. Factually, I'm saying, you know.
So you raise
My lord, so far as
up to Badrun Nisa selling to these 4 people.
no, till Badul Nesha, I admit.
All right.
Till Badul Nesha.
Till Badrun. Very good.
Now, your losses, then your losses kindly see, according to us, Badrun Nisa sold it 12th October 1992 to Lakshmi Mahato
See.
and Besi Mahato.
Lakshmi Besi, Fulchand Sathia.
That is
Lakshmi and Besi sold to these people.
I am appearing on behalf of
Mahato and Besi Mahato sold it
Chandan Boral.
to
Who is the
Chandan
applicant?
Bora.
He's one of
He
the-
is now the appellant before lawsuits, one of the appellants.
So date that purchase wrong.
Purchased on your lordships, kindly have a look at this. Purchased on Chandan Boral
Wrong, I got it.
on 1st October
No-
20
November.
November 1st November 2022.
But Majid Khan is the first appellant. How does he claim?
Right, Majid Khan.
Majid
Yes,
Khan
your
is
first
applicant.
appellant is Majid Khan in the
That,
MAT.
the other one.
I was a respondent with petition.
Respondent.
You are placing item 7 first. Item 7 is Majid Khan.
Majid Khan.
Majid Khan is one of the
One of
He is
the
one of
claimant and respondent.
There
Because
is-
of-
It is your appeal.
Yes.
Yes, yes.
So you are Majid Khan and others.
Majid Khan and others.
One is Chandan Boral.
Chandan
How does your client claim? Majid?
Majid, because of his lawsuit, Abed Ali Khan.
Directly through
They
us.
direct,
That remains.
that remains.
Very.
Now, this Chandan Boral got it 1st November 2022
Yes.
by way of sale. Mala sale did annex to this. What happened, your lordships? Lakshmi Mahato and Besi Mahato,
Yes.
after getting it in 1992, filed a suit in 2020 against legal heirs of Muhammad Khan,
Including Nani,
including Nani.
who was one of the petitioners.
Now, kindly take note of the suit number 91 of 2022.
20.
20, sorry, madam.
That is annexed to the application.
That is annexed, everything annexed, my lord, to the stay application or the writ petition.
Sale date doesn't annex. আমাদের সে sale date does not annex.
ऐसे दिए दे रहा है।
Right.
Now, Malak, kindly see the suit of 2020, 91 of 2020, filed by Lakshmi Mahato and Besi Mahato against the legal heirs of Muhammad Khan. Malak, he filed a declaration suit because they are disturbing his position and right. There, they filed it. What happened, Malak, after filing the suit? These 2 persons, Lakshmi Mahato and Besi Mahato, sold to Chandan Bora. But
He purchased with the suit. With the suit on his.
so this, Malak,
He got implemented.
no, what happened, dear lordships? Lakshmi Mahato and Besi Mahato, after selling it to them, we do the suit. Yeah, I do not have any interest no longer.
Wow.
That's Malad, only Malad. Possession was being disturbed.
But they claim title also.
Yes.
Malad, I think your lordship on the basis of the declaratory suit, I find that I will be placed.
What would be the effect of that?
That's my lord the point. They said that I have sold it to Chandan, but Chandan's title nobody questioned as of today. I will stand corrected.
Chandan, whatever Lakshmi and Besi had, Chandan will have.
That,
If they had nothing, he'd have nothing.
but your lordship's first concern, Badrun Nesa's title was not disputed.
So you say, supposing what would be the effect of the dismissal of the declaration suit? Even if it is dismissed independently, you say But then Chandan is barred by order 23. Suit is dismissed for default or withdrawn. Withdrawn. Order 23 barred by order 23 rule 1. He steps into the shoes of those two people. As against Muhammad Khan's heirs, Chandan would be barred.
No, I here
File a suit for compensation against Lokhi and Mapesima.
here is determined. That's my point. Malad, if somebody suppose, as my learned friend says, up to 1992, they didn't dispute.
No, we understand. But the moment the suit was filed and you purchased during pendency of the suit, Mr. Shanal, don't you at least pendency and you step into the shoes, that concept comes in. Whatever they have right, you have the same right. So today, could Lakshmi and Besi Mahato resile from that withdrawal of the suit and challenge the title of
Malad, I tell you, lordship.
Muhammad Khan's heirs?
What I'm saying, your lordship.
This is the wrong court for you.
No, Malad, it's right court.
Right court.
right court. No, Malad, Badrunesha title, if not disputed, then Malad, Lakshmi Mahato and Besi Mahato's title cannot be disputed. My point is that. That's the only point for disturbance in possession. And that's why consequential declaratory suit. Nobody questioned Lakshmi Mahato, Besi Mahato. During pendency of that suit, they withdraw it and sold, Malad, during the sold it. Malad,
where is the plaint annexed? That suit. Before going further, we just look.
Page 30.
Sir. Falam nane sabar.
Page 3.
Withdraw করে দিল। These are the very people, they were the defendants in that suit. How can you get over this? We were thinking in your line whether we can get over this or around this. Against him, we were thinking, but how can we? They were specifically that Nane Khan was a defendant there.
Certainly, Madam. That's why I'm giving this chart, your lordship. Now, your lordships, if the Nani Khan, suppose your lordships, there is no suit today. This suit.
It would be different.
I tell lordship. They have not claimed their right title interest in the property. It's a matter ultimately apportionment and compensation.
That would be a very dangerous proposition. Once a suit is filed, Mr. Shannal, and we cannot go back to a point of time when the suit was not filed. If no suit is filed, no difficulty. But if a suit is filed withdrawn against the self-same person's subsequent purchases by virtue of section 52 and principle under order 23, unless they are debarred by law, I mean, it will be a very risky proposition. Anybody can reopen after withdrawing. I file a suit, see some difficulty, withdraw the suit, and then say that no, previously I had right. So once a suit is filed, your right is dependent on the outcome of the suit. If the suit was not filed, we could have a very cozy case, if you may say. But
nobody has challenged Chandan for us.
That's why we are saying it's a wrong code. Order 23 is
my point is
burnt into our minds from practice days.
all that I'm trying to submit your loss.
Yes.
If Badrun Nesha's title is not disputed, can anyone dispute the title?
Not disputed
Nesha
is not equivalent to admission by way of a pleading or something like that.
No, that,
they are not disputing. They have not raised any dispute to Badrun Nesha's title.
Badrun Nesha.
But they may very well say that no, this they filed a written statement in this suit.
Yes, written statement.
They must have taken a stand that they have title.
I'll be trying to.
Did they say that they have title?
No, that's my point.
Is the written statement annexed?
Written annexed
should have been. Is it with you?
I had seen once.
Mr. Banerjee, don't try to hide that.
My lord, kindly
Because
take page,
Will not hide.
No, he will.
No, he
kindly
will
takes
not.
page 85 once. Sir,
Oh,
sorry.
no, that's your losses. I will be placing it. That's
Kindly
my
takes
lord.
page 85.
Acha will come to
Very well. Let my learned senior friend come.
I will place it your losses. My lord, at the time of withdrawal, that was. My lord, all that I am trying to make your losses. There is no counter title. No, he has not derived any title. I have deriving the
Need not be.
title.
Order 23 is irrespective of that. You know that, Mr. Shah. Whatever you are saying, you know. All of you know. Whoever is on this side, on your side, up to the back. So, yes, we understand no counterclaim. They have not claimed title. Your vendors did the mischief. Allowed in part. Why allowed in part?
No right to file further suit.
They sort of right to file.
No, my lord, they sought it. My lord, I tell you losses.
That was specifically refused. Page 85. Yes. You should have preferred something against this. If not a consent decree, that at least for recall is allowed in part, permitted to withdraw as a whole without any liberty specifically given.
That's my lord, that's to
How can we reopen that, Mr. Sharma? We
No,
cannot.
I'm not asking to reopen your losses. Your losses.
You don't
No, this is not the subject also. All that
have a case, then no locus standi then.
No, all that I'm trying to say, Malad, there is no dispute regarding the proper right title and property, interest in the property. Of Malad, even of
If we
Chandon
say that there is no dispute, then we have to say there is no dispute because you don't have any right title and interest. That is the difficulty in this case, Mr. Chana. To hold that there is, otherwise there would be a dispute. Because it's obviously it's a dispute because both of you are before us.
Malad, here I am
To say that there is no dispute, we have to say you don't have any title, therefore you don't. There is no dispute.
Malad, this is one way, Malad, straight way, Malad.
What is the other way? We are trying to
Other
find.
way I'm trying to.
Yes.
Dispute means what? What dispute means? Somebody raises a dispute, it's a dispute. So he must have some ground that this is my basis and this is the dispute. What is the nani and others? That's why I'm taking your losses through entire tree. What's the ultimately at the end of it?
You cannot, at your instance, you cannot raise this question. That is the difficulty. Even if they don't independently haven't have their right or title thrashed before any civil court or somewhere, you cannot dispute that title. You cannot raise the question. You cannot challenge their title, their exclusive title in the property after this, because whatever is the scheduled property in that suit, you are bound by order 23 after this, squarely bound due to page 85. So order 23 debars you from staking any claim. Or if you go one step further, you may argue, we will consider that even without, it does not take away your title in the property, but you cannot file a suit. Independently, you can take a defense. Let us see order 23 language.
Civil procedure.
Mr. Banerjee would be cursing us.
No.
But only one thing is I shall add, my lord, after my learned you can see.
Yes.
But what happened, my lord? I
He's coming from the
admit-
family court. Yes.
I admit the ownership of Badrunisa up to Badrunisa. But thereafter, what happened? I'm some of the respondent. Badrunisa sold some portion to me. Some
No,
portion to
first we'll hear Mr. Banerjee. He has a prior right.
some portion
You are
to the
supporting him.
client of my learned senior friend.
Let us hear. We have not.
My deed has been nullified by the lordship, by way of the order by the under 3CX.
All right. Precluded from instituting any fresh suit. So you cannot file a fresh suit. But you may argue probably that your title does not, your substantive right does not go. You can take it as a defense.
Kindly mind your losses.
Somewhat like limitation or order 909 even.
Kindly, Malad, What is the subject matter before your lawsuits? Apportionment of claim on the
For which there has to be a dispute.
What is the dispute? Here, my lord, I will take your lawsuit to the Supreme Court judgment.
Why do you say there is no dispute?
Because I tell your lawsuit, title is not questioned.
They don't question.
Title nobody questions.
Nobody.
Neither your lordship Lokshmi Mahato, Besi Mahato.
They filed a writ petition seeking transfer to the civil court of original. Their writ petition, they seek.
Question the competence authority order. I will take your law.
Yes, on the ground that civil court should have decided. Therefore,
Exactly.
implicitly they say there is a dispute.
What is dispute? As I'm saying, my lord, I will take the judgment.
Before the competent authority, they did not file any statement or did not raise any dispute.
Well, of course, that will also I will
Then-
take your- But dispute means, my lord, wow, somebody just makes a dispute. Suppose all that I'm trying to make your lawsuits. My title deed is not disputed.
If he makes a dispute, raises a dispute for the competent authority, that is a dispute, Mr. Shandal. Otherwise, there will be nothing for the civil court to decide. Civil court's power to decide a dispute also includes whether it's a dispute in the eye of law or not.
That's not all.
Because to say that this is not a dispute, Mr. Shandal, prima facie adjudication has to be there.
Yes, everything what will come from your losses towards me. I know.
Obviously,
That's
yes.
all that I'm trying to your losses. That must be substantial dispute to be decided by the civil court.
What can be more substantial? Apportionment depends on the.
A person depend on right title interest in the property.
Yes.
What is that right title interest? Whose claim that I have a right?
Before the competent authority, they must have claimed.
Take the loss of.
Acha, let us look into that.
Please go page 92. Page 92.
Page 92. Line 93 will be, I think, your losses.
All right.
The appropriate order. Well, may I just read out with your losses? 27th November 2024, order number 4.
Yes.
Page number 9. I have perused all the material documents produced before me. On perusal of the case records and from the submission of the parties, the brief fact of the case is summarized below. A. The subject properties were purchased in the year 1935 by the registered deed being such and such by one Nasrat Ali Khan, son of late Sujat Ali Khan. Said Nasrat Ali Khan died leaving behind two sons, namely Muhammad Khan and Abed Ali Khan, and two daughters, namely Jamal Banu and Jahan Bibi, as his only legal heirs. B. Later on, Muhammad Khan by deed number such and such in the year 1951 sold his entire share in the said properties in favor of Sahidan Bibi and Nasiban Bibi. Abid Ali Khan transferred his shares to his wife Akbar Bibi by the registered deed number such and such in 1960. Nasiban Bibi filed a title suit in the year 1962 being such and such. The suit was disposed of in 1966 on compromise decree with a preliminary decree. In the order, it was mentioned if the defendant number 2 pays a sum of rupees 750 to the plaintiff and defendant number 1 within the stipulated period, then the shares of those properties will devolve upon the defendant number 2 and the plaintiff and defendant number 1 will be debarred from laying any claim over the partible estate. Accordingly, the sum of amount of rupees 1,500 was placed to the plaintiff and defendant number 1. Therefore, the defendant number 2, Muhammad Khan, again regained the properties which he sold to the plaintiff and defendant. Therefore, properties of Nasrat Ali Khan devolved upon his two sons, namely Abed Ali Khan and Muhammad Khan, and two daughters, namely Jamal Banu and Jawan Bibi. Said Jamal Banu and Jahan Bibi and their husband died issueless. Therefore, the property of Nasrat Ali Khan devolved upon his two sons, namely Abed Ali Khan and Muhammad. Abed Ali Khan transfers his share to his wife Akbar Bibi, registered being in the year 1960. Abed Ali Khan and his wife Akbar Bibi died leaving behind one son, namely Majid Khan, and one daughter, namely Asma Begum Khan. Therefore, the half share of Abed Ali Khan devolved upon Majid Khan and Asma Begum Khan. Now, in terms of the claim of Anadi Mahato and Srimati Mahato, this is to state that the predecessors of Anadi Mahato and Srimati Mahato got the plot number such and such with area such and such from Muhammad Khan by deed number in the year 1985. But Muhammad Khan in the 1973 transferred his share to his wife Badrun Bibi by the registered deed number 9. So, how could it be? It is a dispute, Malad.
If Badrunnesa's title is admitted, then Muhammad Khan does not have anything left.
Point.
Well, may I?
We have not heard it, Mr. Ghosh. Please take your seat. No, you are not supporting them. You are for the other side.
I'm supporting the writ petition.
Yes, then take your seat. We have not yet heard the writ petition. We are hearing the appellant. Why are you disturbing the court at every time? Let the appellant finish. Then Mr. Banerjee will be invited. Then you will come up. You never filed any writ petition. Your rights are affected. You will be heard last. Yes, please continue.
Therefore, claim of Anadi Mahato and Srimati Mahato cannot be entertained as execution of their deed was in the year 1985. Later on, said Badrunnesa Bibi in several occasions sold the subject property to many others. Therefore, the claim of the legal heirs of Muhammad Khan also rejected. Now, your losses, the material point also. One Faisal Khan, I have given your losses in my.
He's one of the writ petitioners.
One of the writ petitioner, Faisal Khan. Who is Faisal Khan? I will also say I have the schedule and place it there. One Faisal Khan claims that his grandmother Sahidan Bibi gifted the entire property to him in 2020. How is it possible, madam? But from here, a title suit number such as 1962, it appears the defendant number 2.
So, what is the date of that gift, grandmother? 2020. Yes. Much after Saidan entered into that compromise again giving back. Yes.
Khan pays a sum of rupees 750 to the plaintiff Nasiban Bibi and such. Thus, the share of Nasiban Bibi and Sahidan Bibi devolved upon to defendant number 2, Muhammad Khan, and the plaintiff and who will be debarred from laying or claim over the particular estate. Thus, the claim of Faisal Khan be rejected. Then, Muhammad Khan, being the owner of 50% share of the subject plot, gifted his share to his Badrunnesa, it being such and such deed number in the year 1973. Subsequently, Badrunnesa sold the property to Lakshmi Mahato and Beri Mahato and Fulchand Satya in various deeds in such as. Well, kindly see all the date of deed. Up to this also not disputed.
No, I'm disputing.
According to me. Up to Badrunnesa, everybody admits. So Badrunnesa's title, I can understand. If somebody says the Badrunnesa deed execution deed is absolutely fake deed and laid a claim in the competent civil court, I could have understood. That's not the point. So as of today, execution of deed by Badrunnesa to Lakshmi Mahato and Beshi Mahato still on the field. Somebody dispute possession right, but that's another aspect I will be taking. I am in possession every time my maleficence comes and disturbs me. I file the suit because declaratory suit I have to file when I protect my possession. Therefore, your losses will find after that says Lakshmi Mahato and Beri Mahato appointed Santosh Kumar Mukherjee and Haradhan Sahu as power of attorney and sold the property to Chandan Bora. Now I came into it. Samuel Pandey, Sutanu Banerjee, by the registered deed number 2 and 2 are out of such and such. In an affidavit being such as the Chandan Bora declares he is in possession over plot number such and such with area such and such, which he bought by the registered deed of 2020. In terms of the claims of Adalat Mahato and such and 6 others, this is to state their predecessor in interest, Kalipodo Mahato, Nepal Gorai, purchased an area such and such over plot number such and such from Badrunnesa Bibi by the registered deed number such and such of 2005, which cannot be considered at this time. Well, these are part we are not considering. So this is the my lord. Then what is the dispute?
They were on notice, they appeared.
Everybody was heard.
Acha, did they file any statement, written statement
There
in
was
that proceeding?
one
Page 46.
one document.
46 is our
No,
complaint by
46
them.
আমরা দিয়েছি।
Very complaint.
I think.
On the basis of his statement.
That's uncommon.
In that, where have they admitted the title up to Badrunisa? That we
No,
want.
no, and this entire chain of dispute, they are legal losses up to page 48.
Page 51.
I get your losses then. They, everything, I do not find any dispute.
Paragraph 12
Mal-
is page
12
50.
mal- page 50 and 51.
Yes.
That's well, I think Roman 11, I should say. It is very unfortunate that though Muhammad Khan the ownership right has dated, yet there has been an erroneous recording and arrest recorder which was recorded in the name of Muhammad Khan as Jordan. It is tried to mention in this regard that an erroneous recording of recorder has no legs to stand unless supported by clear and cogent right title. In this title lied upon the applicant's predecessor Muhammad Khan.
No, but it says 12, Roman 12, they say by dint of a registered deed of gift, he had transferred such a scheduled plot.
Entire plot.
That is the entire plot. To his wife, Muhammad Badrunisa. Therefore, they admit up to that.
Okay, paragraph 30. In the meantime, two individuals, Lakshmi Mahato and Beni Mahato,
They speak about that suit and all.
so
52.
52 your losses kind of.
Yes.
40. That as the affected persons are Muslim or Mohammedan by religion, hence devolution of interest or share, affected persons are to be calculated under the provisions of Muslim personal law or Mohammedan law, and the applicants reserve the right to submit appropriate document mufti.
So this is contradictory. In Roman 12, they say transferred in favor of Muhammad Badrunisa, but then they say the applicants are legal heirs and Muhammad Sajasa. Therefore, in terms of personal law, share is to be divided among legal heirs of the deceased.
Mufti is not legal.
No, page 51.
51. I want to say
Just before 13, Roman 13. They say that
applicants are legal heirs of the deceased Muhammad Khan, therefore,
definitely, but the previous sentence says it was gifted to. Is there any bar in Mohammedan law to give the entire property to Badrunisa? There is no. They also have not taken that point. So then this is contradictory. They say that it was gifted.
and with this, your losses, read Malak, kindly read Malak next page, paragraph 14.
Yes. 14 we have read.
So, what is the dispute?
So what? Let us see how the learned single judge proceeded.
Page 95.
Page 95. Well, two things are very common your losses. Now, so for central government, your losses appear whenever people losses will find national security. So
Yes.
for we appear for CSC, we will say, my lord, that this is technical defect. And now another development, your losses disputed question, read court should to Jordan and get back to that. Look, this
That's
is
easier for us.
that's what I'm taking this. Otherwise,
But
that
there
is
are
not-
contrary judgments also. Disputed question, unless they are so disputed that evidence will.
Especially as Supreme Court has said, this sort of stoic argument you should not take. And court can go into this.
What is it?
Now, your losses.
That judgment.
Page 1.
Similar relevant page, page 1. The
সিঙ্গেলে বসে একটু গুছিয়ে দিতে হবে আপনাকে টেনশনে বসে দিলে আপনি লোকেরা বলবে শুভ হয়েছে বলে দিচ্ছে আপনার যে জাজমেন্টটা সেটা কেউ কিছু বলেনি কিন্তু আমাকে কনগ্রেচুলেশন আমি সিঙ্গেল আপনাকে বড় দিতেই হবে বড় না হলে গুছিয়ে
I think factual.
yes you can
Paragraph 5. In course of submission, Mr. Banerjee, learned advocate, appearing on behalf of the writ petitioners and the private respondent in another writ petition at the very outset, draws attention of this court to the provisions. I will take your lordships to these provisions. At this juncture, Mr. Banerjee took me to the copy of the order number such and such has been annexed to the writ petition. It is submitted by Mr. Banerjee that on perusal of the said order under challenge, it is revealed that the respondent authority had practically acted as civil court while discharging his obligation. I will take your losses to the scope of this. It is submitted by Mr. Banerjee that under section 3I of the said act, the power of the titular act of the civil court is very much limited. Inasmuch the said section 3I clearly specifies the peripheries within which the said competent authority can act. It is further submitted by Mr. Banerjee that by no stretch of imagination it can be said that section 3H 3 and 4 of the said Act of 1956 empowers the respondent hearing to determine the dispute, which is essentially within the domain of principal civil court. In course of his submission, Mr. Banerjee also draws the attention of the court at page number such and such, being a certified copy of the judgment as passed in suit partition such and such, which was decreed in the preliminary form by the jurisdiction. Attention of this court is also drawn to page number such and such in the extant petition, as well as the copy of the withdrawal of this. Now here, it is also submitted by Mr. Banerjee that in the event the contents of the said preliminary degree and the contents of the order of withdrawal and the order which is under challenge, before they are looked together, it would reveal that the respondent authority, while making the order, had practically made an appeal to go into the title. Oh, this part is absolutely wrong, according to me, of course.
It's submission.
Then your losses, submission, of course, claiming award in connection with the land acquisition proceedings, and therefore the said authority has exceeded its limits as imposed by law, and therefore the said action of the said becomes amenable to the jurisdiction as subject to judicial review. In the course of submissions, Mr. places the reliance of the judgment of such and such. I will take your losses to the judgment of.
But 3H3 has been quoted here. 3H3 says that where several persons claim to be interested, competent authority shall determine the persons who in its opinion are entitled.
Exactly.
So therefore,
4
says if any dispute is the next stage, dispute as to apportionment of the amount. But the entitlement primarily under 3H3 apparently the...
That's my point, your loss. If I read together, a
Yes.
section has to be read as a whole.
Entitlement comes first. Entitlement shall be decided by competent tribunal, competent authority. Then if there is a dispute as to apportionment, it goes to the...
If I'm not wrong, your losses is the subject authority of this.
Here at
But
the
partition should like.
the 3H3 stage, competent authority has decided that they don't have title. Entitlement has been decided. After that entitlement decision, if there is no question of any dispute as to apportionment, this Mr. Banerjee and Mr. Ghosh will answer. That's why I'm telling this. Prima facie, you have a good case on that.
Well, all that I after going through the judgment of the learned
Yes.
judge, there the learned single judge has relied upon the Supreme Court judgment also. Probably this is the mind of the learned single judge. If somebody comes and disputes it, it should go to civil.
Disputes what? That is very important.
That's my lord. Here, if I go your losses to the all the submissions of paragraph of Mr. Banerjee, your losses will find preliminary decree also they are questioning. That cannot be questioned. I will take your losses to the Supreme Court judgment. Of course, my lord, sometimes this is binding upon us somewhere.
Yes.
But always not a good my lord one.
So
I'm
this,
not here your losses to point out that.
thin line of distinction, the court says. Let us come to the findings of the court.
Exactly.
Para 28 onwards, I think.
It is. Keeping in mind the aforementioned legislative provisions and also keeping in mind the propositions of law as decided in various reported decisions as I've cited from the bar. If I look to the factual aspect of this case, it appears to the case that while making an order of apportionment in respect of the award in connection with acquired plot number such and such, the respondent of a four authority undoubtedly relied upon the judgment of preliminary decree on such and such. The said revenue authority had dealt with the family trees of one Nasrat Ali Khan, thus gave a vivid description as to how title to the said acquired properties passes in favor of one Badrun Nesabi. The said authority has practically relied upon the judgment and order in title suit number, whereby preliminary decree of the partner was passed determining the shares. It thus appears to this court that the basically the respondent had relied upon the determination of shares in making an order for apportionment, which is under challenge in the instant writ petition. It further appears to this court that while arriving at its finding on the cover of the said order under challenge dated such and such, the respondent of a court authority had also relied upon the order of withdrawal as has been instituted by such and such. However, from the relevant portion of the order under it appears to the court that they had made no attempt to come to a finding with regard to the effect of withdrawal of the suit. And the contrary, he made an investigation, ultimately came to a finding that the said plaintiff had practically no shares in the said acquired plot by virtue of the sale through their power of attorney holder, and doing so, considered view of the court has stands here. This is more than taking. I take your losses, full consideration of your losses view in order 23. Even then, title is not posted, I may be debarred from doing certain things. But what about an apportionment? My property has been taken away, my lord. If your losses visualize it, everyone, whosoever claims if your losses now nobody has the property. Property has been gone. Now you have to get your fruit of that property by your compensation. That's the title. That's what I'm saying, Malak. If one comes before the authorities for sake of dispute, then, my lord, this is not the right judgment.
And under 3I, competent authority has the powers of the suit.
Now, how the Supreme Court read it, can you see? With folded hands, permit me, this is a binding upon judgment, upon your lawsuits also. But your lawsuits sometimes kindly read between the lines. I request your lawsuits. How the Supreme Court read it?
Mr. Chaudhary will be supporting you. We see him on screen.
Yes.
Yes.
Very well. Yes.
Your Lordship, this is reported in live law. Live. Unfortunately, I just SCC online. I just
Live law is now equivalent to YouTube.
Just a minute, which one? I follow otherwise.
Only the sensational things, age-old propositions of law every day coming out. A new sensational judgment as ratio has been laid down. You know from law college that proposition. Every other day, bar and bench, live law. We don't want to name anything on screen, but good to know the latest developments. Interesting ones, more than judgments. You are earning sufficiently, Mr. Banerjee. Why are you citing live law judgments?
no. I have SCC online, but unfortunately,
This is not.
That's not in my brief right now. It's not. My
Say
lord,
that.
kindly pardon me, my lord.
Yes, you are pardoned.
SCC online, my lord. I just
You do subscribe.
yes, I do subscribe. It's
Then
in my.
you're citing live law.
Unfortunately, it's not here right now. That's
Vinod Kumar, this case.
Yes.
Well, factual background, if necessary, I will take your losses. But your losses kindly straightway come to page 9, paragraph 19. Page 19.
কুকুরের ব্যাপার ছিল কুকুরের ব্যাপার This pertain only to human beings, this apportionment. No, this no dogs or any other. Yes. কালকে দেখবেন আমার পাঠিয়ে দিল ত্রিপুরা এটা শোনার পর প্যারা 27
No, 19.
19 19 is the section quoted. Yes.
Yes. Now your losses straightway come to
Did you want to place score?
22.
22 page 4 has been yes.
With respect to deposit and payment.
23 onwards the ratio.
The scheme of the Act of 1956 and the statutory provisions referred to above makes it very clear that once a land is acquired under the Act of 1956, the competent authority is obliged to pay an amount by your compensation. There is a procedure which has been prescribed under Section 3G of the Act 1956. Subclause 5 of Section 3G makes it abundantly clear that if the amount determined by the competent authority under subsection 1 or subsection 2 of Section 3G is not acceptable to either of the parties, the amount will have to be determined by the arbitrator, which may be appointed by the central government on the strength of an application by either of the parties. Section 3H provides that the amount determines towards compensation under Section 3G will have to be deposited by the central government in accordance with the rules. It is only after such amount is deposited by the competent authority that the possession of the land can be taken. Subclause 4 of Section 3H talks about apportionment of amount. The language of subsection 4 of Section 3H is plain and simple. It provides that if any dispute arises as to the apportionment of the amount or any part thereof, the competent authority is obliged to refer the dispute to the decision of the principal civil court of original jurisdiction within the limit of which the land is situated.
3H3 has not been considered at all.
Exactly. That's my point.
With utmost respect.
With all lesson, now let us proceed your law. We have to, in the case on hand, the High Court seems to have completely misread the provisions of the Act. It's very easy to someone accuse. No, it fell into error as it failed to apply the well-settled principle of law that for construing a legal provision, the first and foremost rule of construction is the literal construction. Everybody knows it, madam. All that the court has to see at the very outset is what does the provision state. If the provision is unambiguous and from the provision the legislative intent is clear, the court need not call into the aid of the other rules of construction of statute. The other rules of construction are called into aid only when the legislative intent is clear. It may be mentioned that in the aforesaid context, the first and foremost principle of interpretation of a statute in every system of interpretation is the literal rule of interpretation. The other rules of interpretation, for example, mischief rule, composite construction, etc., can only be resorted to when the plain words of statute are ambiguous or lead to no intelligible results, or if read literally, would nullify the very object of the statute. Where the words of a statute are absolutely clear and unambiguous, the recourse cannot be had to the principles of interpretation other than the literal rule. The language employed in a statute is the determinative factor of the legislative intent. The legislature is presumed to have made no mistakes. The presumption is that it is intended to say what it has said. Assuming there is a defect or an omission of the words used by the according to my little knowledge, paragraph 23 is redundant. If you also permit me to say that I have great respect on this is not necessary. Everybody whosoever come across the law college, he knows it now by this. At least 5-year students are well educated. There is a fine distinction between the determining the amount to be paid towards compensation and apportionment of the amount.
Law student. Generally, the law associates are fresh law graduates. The law associates we have who help us in our. You're not totally off the track while saying that.
Oh.
Yes.
Now, there is a fine distinction between determining the amount to be paid towards compensation and the apportionment of the amount. The legislature has thought it fit to confer powers upon the principal civil court to determine the dispute arising out of the apportionment. But I think, certain paragraphs law has been wrongly constituted. Wrongly constituted law. If this we accept, my lord, whosoever comes and disputes it because of blood feud, in every family, my lord, this will be then.
How do we get over 3? We can't understand. But this is an occasion where several persons claim to be interested in the amount. That obstacle has to be overcome first. Once that is overcome, here that has not been overcome because it has been held. That has to be decided by the competent authority. Says that some person is not entitled, the others are entitled. Then the question, because even after it may be argued that apportionment, and there is a thin line of distinction, not only between apportionment and valuation, but also regarding entitlement and apportionment. No, because after we hold that you are entitled to half and he is entitled to half, we may say, we may consider what portion should be given to you because you may be in occupation of a better portion. You might have been in occupation of the immediately roadside portion. Therefore, your compensation may be certainly more.
That's your loss.
That is apportionment.
That's your apportionment.
That is apportionment. You may not get 50. You may get 51% because of the thing which you are giving up. the position. We can take that into consideration.
That's another aspect.
That is apportionment.
That's
That is what we say. Entitlement 3 and 4 are different.
Yeah.
Apportionment is not intertwined with entitlement. It does not mean that apportionment means entitlement. We have just declare our shares, and that is apportionment.
What the partition should. Preliminary degree passing, is entitling the share, making the
Yes,
fixed one.
yes.
Now, when it is divisible, then comes divisible property. Who
Yes.
is in the possession? Which
Yes.
portion is the property in the possession? That's my lord, by way of advocate commissioner, your lawsuit determine it. Now, where is that case, my lord? The
All right.
single judge interfered with.
All right. So,
That's my point.
any other judgment? This is the
No, this is solely
No.
relied upon.
Ask.
Solely relied upon.
So let us hear the other.
That's my give me 5 minutes till I'll come back to that. Malad,
What? Now?
No.
You have finished your argument for the
Yes,
present.
that's your lawsuit's present.
Yes.
That's
5 minutes, you'll go somewhere else. Yes, absolutely.
My junior will be here.
Yes.
Thank you.
Your Lordship, first, my lord, may I take your lordships to the legislative mandate? It fell from your lordship
Yes.
that entitlement and apportionment.
Apportionment.
My endeavor before your lordship is that section 3H4 stays of entitlement. How? My lord, may I place the entire section 3H from the very beginning?
Absolutely.
But I'll come to the factual aspect later. May I first
Later.
let's see legislative intent. The amount determined under section 3G shall be deposited by the central government in such manner as may be laid down by the rules made in this behalf by that government with the competent authority before taking possession of the land. As soon as may be after the amount has been deposited under subsection 1, the competent authority shall on behalf of the central government pay the amount to the person or the persons entitled to. Thereafter, my lord, where several persons claim to be interested in the amount deposited under subsection 1. So several persons are interested. Everyone is saying, I am entitled. It's not the question of apportionment. Everyone is saying that I am entitled. It might be the whole.
It's a question of entitlement.
Entitlement. It might be the whole. It might be a fraction.
Agreed.
Any entitlement.
Agreed.
The competent authority shall determine the persons who, in its opinion, are entitled to receive the amount payable to each of them. Very well. Thereafter, kindly takes 3H4. If any dispute arises, dispute in between ourselves, as to the apportionment of the amount, there.
So this dispute should be, let us proceed on. This dispute should be, according to you, between the persons who have been held to be entitled under.
No. Thereafter, my lord, I'll just place. Or any part thereof. Thereafter, my lord, kindly mark these words. Or to any persons to whom the same or any part thereof is payable.
So there
any person. My argument before your lordship is any person who is seeking entitlement.
No. This or is meaningless. If any dispute arises as to the
apportionment of
two disputes, two types of dispute. One is as to the apportionment of the amount of any part, but or to any person.
Or to any person. Thereafter, I'll just. If any dispute arises to any apportionment of the amount, that is one part of the provision. Apportionment.
Then
any person cannot or any part thereof in apportionment's part.
Yes.
That's one part. Therefore, there are
yes.
Two contemplations. Now, the third contemplation, which I am harping upon, or to any person to whom the same, or to any person to whom the same, or any part thereof is at all paid.
This or, if your argument, this is disjunctive, it has to be, this or has to relate independently to if any dispute arises.
Yes.
If any dispute arises as to the apportionment, or if any dispute arises
as to the entitlement
to any person.
To entitlement.
Then the sentence would read, if you leave aside as to apportionment of the amount or any part, that has to be left out for the purpose of this, up to thereof. As to thereof. Now, then it will be if any dispute arises
or to any person
To whom arises as to any, but this to then would be redundant before any person. Then it would be if any dispute arises as to any person.
To whom the same. Legislature has used the word to whom the same.
Or any part thereof is payable, that is
Yes,
the person
whether
decided
he is
under
at all-
subsection 3.
Whether at all, therefore, who will be entitled? To whom the same.
See, legislature, any statute, the rule of interpretation is that will skew superfluity, will curtail superfluity. Legislature cannot use same expressions over and over again. That is the premise.
Why
Now, why 3 and 4 then would overlap?
Because one complements the other, and my lord,
If it has to complement, then this to whom the same or any part thereof is payable are the persons who have been decided to be so payable.
No.
Under 3.
No. Why I tell your lordship? Because if I go through section
What
3,
is the distinction between the persons who are entitled to receive amount and to whom they are payable? I am entitled to receive means it is payable to me. There is no distinction between the two.
I tell your lordship.
There cannot be a third category. One not entitled, but it will be payable.
No. I am trying to convince your lordship to any person who is at all entitled to whom the same. Because
what is the use of section 3 exercise, subsection 3 exercise?
Yes, because I tell your lordship, now kindly take section 3I once. Why it has been laid down? 3I would elucidate.
Yes.
Kindly takes. I'll
Yes.
for 3H5 and 3I.
I supports more what against you than what you are saying.
What 3I says.
It has the powers of a civil court, competent authority.
No, what powers have been prescribed?
This is the general thing in all
No,
statutes,
I'll just
wherever authorities are given for.
Malad,
It's a copy paste from other
Malad,
statutes.
this has been gone into by the decision which was placed by before the honorable single bench.
This is for the power. These powers are for the exercise of the authority vested under subsection 3.
Yes.
The powers are not independent in thin air.
Malad,
These powers can be exercised by the competent authority to exercise the power vested in it under subsection 3.
My lord, then I am asking this question to myself.
Yes.
Can the competent authority decide on a question of title?
Basically, yes. That is what it decides. Because entitlement is the adjective of title, Mr. Banerjee.
Suppose.
If I have title, then I am entitled.
Suppose in the given case, in our case, what has happened, he has declared a title deed to be void. I'll be placing the order itself. A title deed to be void.
It cannot replace a civil court, obviously.
Yes, that has been.
But he has proceeded on the basis
what has
of
fallen
whatever
from
documents are there.
No, I'll be placing the facts, my lord. Thereafter, my lord would kindly say, takes 3I once for once. 3I.
3I you have read thrice.
My lord, these provisions.
Yes.
These provisions specifically gives the power to the competent authority as to what you can do, what role you can perform. Beyond that, you cannot perform. Now, when it says to what extent you can perform, that is when you can decide as to if there is no question or disputed question of title, then you can straight away go to the entitlement, and you can, if there is a dispute as to the apportionment, in that case you have to relegate it. But where there is a disputed question of title, to my understanding of the entire scheme of the act, the competent authority has no.
You admit the title of Badrunnisa up to Badrunnisa.
Yes.
You don't have any title at all.
I am the legal heirs of Badrunnisa.
You are not the legal heirs of Muhammad Khan.
Muhammad Khan, Badrunnisa, husband, wife.
Yes, Muhammad Khan gave it entirely to Badrunnisa.
Yes.
How can you claim through Muhammad Khan after Muhammad Khan gave it to Badrunnisa? You are claiming through Badrunnisa.
Yes, that was my case.
That title deed have you challenged in any court? Badrunnisa's title deed in favor.
Why should I challenge Badrunnisa's title deed?
Answer yourself. Why should you challenge Mr. Banerjee?
My lord,
if there's a registered title deed, presumption of title comes with it. That's why you should challenge.
No, I tell my lord. May I just clarify, my lord.
They produce the title deeds.
During the lifetime of Badrunnisa, during the lifetime of Muhammad Khan, he had transferred title to Badrunnisa. Thereafter, Muhammad Khan died. Thereafter, Badrunnisa died.
Badrunnisa becomes the exclusive owner.
Badrunnisa,
Muhammad Khan
after
gift it.
Yes. Thereafter, my lord, we being the son of Badrunnisa, my lord, title flows to us.
Even if Badrunisa has transferred her property by registered title deeds
No, these
in favor of third parties.
I tell you, these deeds are subsequent to, but these
Cannot be
deeds,
subsequent to her death.
my lord,
Has to be before her death.
my lord, I tell you, lordship.
And you claim after her death.
No,
Inheritance.
no, not at all, my lord. My lord, just
How can you claim as heirs of Badrunisa when she is alive?
my lord, after her death, I am claiming title from Badrunisa.
But we said you are claiming through her death.
Yes, I am claiming through her death.
Her title, her transfer deeds were executed during her lifetime, obviously.
During her life,
When she parted with her title by these title deeds,
my contention in those specific civil suits were that Badrunisa had never transferred title to those persons. What had happened? May I just place in my own manner, my lord. Muhammad Khan transferred to Badrunisa. We are the legal heirs of Badrunisa. Thereafter, some people come up and say that during Badrunisa's lifetime, she has transferred title.
May I be permitted to intervene, my lord? May I be permitted to just, they are not the heirs of Badrunisa, paragraph 7 of the writ petition.
No, Badrunisa was the wife of Muhammad Khan.
Yeah, they are not the heirs of Badrunisa, paragraph 7 of the writ petition. Page 20.
Writ petition, where is the writ petition?
I'm on page.
Okay. Let us see. Yes, page 20. Where is share with you? No. We'll come to you later, Mr. Khan.
Yes.
Yes.
Now, these people claim that
Yes.
Badrunisa had transferred title. So I was not aware. They institute civil suit. In those civil suits, my lord, they
Don't repeat the facts. We know the facts.
no, there is
that
one.
suit was withdrawn without liberty to fight.
No. In that suit, they have specifically admitted that they have no title to the property. Now, kindly take.
They seek a declaration of title. They've admitted they have no
Yes,
title.
that I'll be placing. Kindly takes.
Take us to that paragraph.
Yes. Kindly takes first page 41.
41 is beyond the plaint. In the plaint where they have admitted.
No, kindly takes page 41. My lord, in their cross-examination, they have.
We cannot look into the cross-examination.
My lord would kindly
Then
take.
withdrawn should know. Sorry.
No, they have said that.
No,
I have
that
the
was
plain-
not adjudicated. There is no adjudication. You cannot look into.
No, my lord would kindly take the principle of estoppel, where the predecessor in interest.
Evidence adduced in a suit, if the suit is not decided either way, cannot create estoppel.
Thereafter, my lord would kindly take page 85 once. Therefore, it is clear from the evidence of PW1 and PW2, plaintiffs do not want to proceed with this suit for this being amicably settled between the parties, and the plaintiffs have no interest and title over the suit property.
This is important.
Now, what the Honorable Single Judge has held. My lord, this aspect was placed by me before the competent authority. This aspect was not gone into by the competent authority. And that is, my lord will find at page.
This is extremely important.
Now kindly takes, that's why
you should have started with this. That's all. Placing 3I and irrelevant things.
My lord would kindly takes paragraph.
So they admitted on that premise it was allowed to be withdrawn without liberty.
Yes.
That takes a different complexion.
And the predecessor of Chandan Baral. Chandan Baral is the appellant before your lordship in one of the matters. Now, your lordship, this entire aspect was not gone into by the competent authority. My learned esteemed senior had placed the order of the competent authority. Now, exactly this is the reason. My lord would kindly.
What's the reason from the learned single judge?
Yes. Kindly takes paragraph 29. It further appears to this court that while arriving its finding under the cover of the said order, challenge dated order under challenge dated such and such, the respondent number 4 authority has relied upon the order of withdrawal of title suit number such as such has been instituted by Lokhi Mahato and Shrimati Mahato as plaintiffs. However, from the relevant portion of the order under challenge as available in paragraph 4 at page 82 of the instant writ petition, it appears that this court, that the respondent number 4 authority made no attempt to come to this finding with regard to the effect of withdrawal of the suit, and on the contrary, he made an investigation, ultimately came to a finding that the plaintiffs of title suit number
That's not the, that's a different ground. That's a different. He does not take note of, the learned single judge does not take note of that observation.
But this has not been gone into by the competent authority. And what the competent authority believes, he takes the affidavit of Chandan Boral. Now, my lord, this is absolutely the rule of the civil court.
Mr. Banerjee, you sought for a transfer, reference to the district court, right? So here, as per the scheme of 3H3, this is entitlement. This also pertains to entitlement. So why shouldn't it be delegated to the competent authority for doing that?
My lord,
because entitlement is competent authority.
My lord, my respectful submission is this.
We have that notion civil courts.
Decide. It is absolutely civil court who will decide.
Yes, because the statute provides otherwise.
I tell your lordship why. In this case,
yes.
Lord, I'll just briefly state the facts. My lord, I am claiming title. We are claiming, rather, we are claiming exclusive title.
Entitlement is title.
We are claiming
3 is very clear.
Just one second. My lord, we are claiming exclusive title.
Yes.
Mr. Ghosh's client is also claiming title, but we are, so though we are on the same boat, but we are disputing that his claim is entitlement. So
you're on different boats on the same current.
Same current. Now, what the competent authority has done, my lord, he has cancelled the deed of Mr. Ghosh's client.
That is that.
Yes.
That's why he was jumping up so many times.
Yes, yes.
So should we let him argue that? Or, show us that portion?
But I'll just place, my lord, page 93, the order of the competent.
Yes.
Page 93 starts. Thereafter, my lord would kindly take page 94.
Faisal?
No. In terms of...
They are the Mahatos?
Yes. And this has been gone into by the Honorable Single Judge. That, my lord, may I place? Paragraph 30.
No, Mahato.
This court also finds sufficient justification in the submission of Mr. Ghosh, in as much as from the last portion of the order date under challenge dated 27/11/2024, the respondent number 4, though took cognizance of the execution of the deeds of conveyance in favor of the family members of the Mahatos, but he came to a finding that those deeds of conveyance as has been executed in favor of Mahato by his vendor, Bodrunesha, has got the effect in the eye of law in view of the fact that Bodrunesha, the vendor of Mahatos, prior to the execution of the deed of conveyance in favor of Mahatos, has sold the entire property prior to 2005.
No. Mahatos, Bodrunesha sold to Mahatos themselves. Chandan Boral and this person, they claim through Mahato only.
No, there are other Mahatos, many Mahatos there. But total, there are 54 applicants who had sought themselves to be entitled.
So the other Mahatos, how could the other Mahatos get title if Bodrunesha sold before their transfer deed?
But
it is evident from the dates. The dates should suffice.
Now,
why should they be relegated to a civil suit beyond the scheme of Section 3? Then Section 3 would say that 3H would say that go to a civil court
to decide your
My
entitlement.
lord, this issue has been gone into by the honorable single bench of our court, where it says that section 3H and 3HI, my lord, runs complement to
Satisfy
each
us
other. and,
independently of the single judge. Satisfy us independently on law. Then what would be the use of 3H3? If the scheme of the legislature was that go to the civil court to decide that, then the entitlement 3 won't be there. Then 3 and 4 would be interchanged.
So, my lords,
3 should have been the district judge. If there is a question, the entitlement will be decided by the district judge,
no, my
apportionment by the competent authority, which would more appeal to the senses. But it is the other way around in the piece of statute.
my lord, may I submit one thing? My lord, then kindly fixes the date. My lord, come
No,
prepare
today
and-
itself, today.
and-
We give you 15 minutes, do that, whatever. you have.
try in my own humble way to convince you.
Absolute, please.
My lord, there are, as per your lordship, my lord, two concepts:
We are
entitlement,
putting it
apportionment,
before you, everything. We are not concluded. We have not concluded.
entitlement and
No final
apportionment.
decision
Yes,
in
no.
our minds also.
So the moment the entitlement is decided, the only thing left is to be decided.
Shut your eyes and listen to us. 3, subsection 3, where several persons claim to be interested in the amount deposited under subsection 1, the competent authority shall determine the persons who, in its opinion, are entitled to receive the amount payable to each of them. 4 says, if any dispute arises as to the apportionment of the amount or any part thereof, or to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court. Keep this in your mind and then argue.
My lord, may I first place a judgment of an honorable single bench? My lord, may I just place, then I'll.
Definitely, yes.
Yes. 2018 SCC Online, Calcutta, page 9903. My lord, this was what has fallen from your lordship, my lord.
All right.
This was in my respectful submission, it was argued. Kindly takes paragraph 4 onwards. Madam.
Yes. Yes.
I am not impressed with the aforesaid submission for the simple reason that if the authority has acted in excess of the power conferred under the statute, the same cannot inure to any benefit of the petitioner at a subsequent stage of the litigation, as the order is palpably contrary to law, which cannot get a blessing of the court, so that the illegality committed shall continue to be committed perpetually. Thereafter, my lord, where I am harping upon paragraph 5. Section 3H4 of the National Highways Act postulates that if any disputes arises as to the apportionment of the amount or any part thereof, or to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction, within the limits of whose jurisdiction the land is situated. Though the reliance is placed upon subsection 3 of section 3H of the said act, but the interpretation sought to be made, if accepted, would destroy the legislative intent, and both the subsections, both the provisions are complementary to each other and does not override others. Subsection 3H, subsection 4 of section 3H is very much expressive, imbibing within its contour any dispute over the amount so determined to be payable to a person if the person's claims. Thereafter, my lord, the court should not lean into interpret the provisions in such a manner that it would invite an anomalous situation, rendering the provisions unworkable. If the competent authority finds that there is a serious dispute over the right, title, and interest in respect of the property acquired under the Act, recourse under subsection 4 of section 3H of the Act should be taken. Otherwise, my lord, how can a competent authority, my lord, decide intrinsic questions? My lord, I had placed before your lordship page 85. There, my lord, the learned court has recorded its finding that this person does not have title. Their predecessor in interest does not have title. This issue requires a good knowledge of a good concept in civil law, which of course the competent authority does not have, in my respectful submission. Therefore, legislature, minors on his own wisdom, found it rightful that whenever there is a serious question of disputed question of title. And now, my lord, another thing, my lord, I just noticed before your lordship, if it may pleases your lordship, kindly take section 3H 3 once. where several persons claim to be interested in the amount deposited under subsection 1, the competent authority shall determine the persons who in its opinion. So who in its,
How do you interpret this according to you?
it's an
In its
opinion.
Read the entire thing. Who in its opinion are entitled to receive the amount.
Entire
Shall determine the persons who in its opinion are entitled, whereas the civil code determines the amount or to any person to whom the same or any part is payable.
Yes.
So
So he has
part is payable to whom or the entitled to whom?
My lord, this opinion
Entitled to receive who, persons who in its opinion are entitled. How do we reconcile this?
My lord,
what will be the scope of that exercise?
If my lord, section 3H3 is my lord read in isolation to section 3H4, my lord, then
let us read the plain meaning first. 3 precedes 4.
Yes, who in its opinion are entitled to receive. So it's an opinion that the competent authority is forming. It's an opinion.
That opinion arises only in a case where several persons are claiming.
Yes, that's an
several persons claiming presupposes there is a dispute between several persons.
That's an opinion. Now that opinion, in my respectful submission, is subject to section 3H4. Otherwise,
of 3 then. What would be the use of 3? It would be a composite subsection which says where several persons claim to be interested in the amount, thus competent authority will refer it to the civil code. That would be the section. Only one subsection would be sufficient. So while courts interpret a statute, we try to cut off superfluities.
Yes, my lord, respond.
You know that the presumption is that statutes are not superfluous. Not a single word is used without there being some meaning to it. So what would be the use of 2 separate subsections? Wherever several persons claim, refer it to the civil code, which would be more rational from a civil perspective. That is, we are speaking against it's counterintuitive in a sense that entitlement is decided by the competent authority, but apportionment is decided by the civil code. It's utterly counterintuitive, but we are not elected, as we say.
And my lord,
these are elected people who have done this.
Now, if my lord, section 3I is now taken into account, which
3I, with deepest respect to you, Mr. Banerjee, has nothing to do with it. This is a general provision in all those provisions where quasi-judicial authorities are given some powers.
Yes.
These exact powers are copy-pasted there.
My lord,
summoning, these are for the exercise of the powers vested otherwise. These are not independent things.
My lord,
for exercising that adjudication, it can summon, take evidence, everything.
Now, my lord, what has happened in my case? My lord, I say that I am the exclusive owner of we say that we are the exclusive owner of the property. Different persons are claiming through their respective title deeds.
Several persons claim to be interested in that.
Several persons claim to be.
Under 3.
And one of them, has come before the court of law and he says that I have no title to that property.
That's on the merits. But the adjudication remains with the competent authority.
That in my
competent authority does not have jurisdiction. Even if you say that had to be decided by the competent authority under 3. You are saying he does not have determination.
My lord, taking into account this judgment.
How do you reconcile 3? 3 should be deleted, rubbed off the statute.
My lord, then the entire provision would become unworkable, as has been laid down by the honorable single judge.
That, with deepest respect, we have some doubts on that. Both views are possible. Learned single judge is much more erudite than me, at least I can speak for myself. But that does not mean every judgment has to be taken as sacrosanct. Just as our judgments are not. Judgments are there to be decided by posterity. And they are up on the pedestal for posterity to decide.
And my lord, may I just place
there is no scope, because the premise of the learned single judge was that it would be the 2 subsections would appear to be mutually destructive and inconsistent to each other. Here we have some difficulty in accepting that. These are not mutually destructive. It may be counterintuitive to the civil mind of the courts, to our minds, but not mutually destructive. If we had no knowledge of law, then it would not be mutually destructive. Competent authority given the power to decide, entitled to receive if there are several claimants, competent authority decides who is in his opinion are entitled to receive the amount payable.
This will give to us very peculiar rise to a
counterintuitive to you. but no peculiarity is there. Legislature feels competent authority is competent to decide the question of entitlement as to who will receive the amount when several claimants are there. That means there is a dispute between the claimants. Or we can read it other way around also. You may argue that yes, several persons are claiming, but then apportionment would be used in 3. There's a confusion of language in 3 and 4. But despite that confusion, meaning can be attributed to 3 and 4. Not that these are mutually destructive, rather these are complementary. Because the learned single judge, while saying that these are mutually destructive, says that both the provisions are complementary.
Yes, these are complementary. And when there is a serious question, disputed question of title, the competent authority has.
Every question of title is serious.
Yes.
There are no seriousness.
No.
It's a
Everything.
question of
Whenever
title.
there is a dispute relation to title, my lord.
Several persons claim মানে হচ্ছে বিভিন্ন person claim করছে। না একটা অ্যামাউন্ট যে অ্যামাউন্টটা হচ্ছে সেভারাল পার্সন এ বলছে আমি পাবো এ বলছে আমি পাবো সেটা ইটসেলফ ডিসপিউট আপনি আর আমি দুজনেই টাকাটা আমার না several persons claim to be interested several persons আপনি বলছেন তো আমার এখানে তো several person claim আছে আনালে তো কোনো প্রবলেম হতো না
Not correct, Mr. Banerjee. If in an affidavit filed, such and such, he says he is in possession. Nothing else. That's not taken forward. Possession is not decided on the basis of that. Rather, he says cannot be considered at this stage as Badruddin sold her property.
Malad, various people are claiming.
Now you have to stop your argument somewhere, Mr. Banerjee. You have concluded your arguments. Cannot reopen every time. Yes, please take your seat. Yes, Mr. Ghosh.
Malad, if you also kindly come to page 92.
92.
The order passed by the competent authority. Malad, I just show your lordship the order number 2, 22nd November 2024. As you can see, the plot which is plotting question is plot number 786. Total area 2.07 acre.
You are respondent numbers in this appeal?
Respondent number 35 to 41.
Very.
In one appeal, and another appeal is lordship.
In
39 to 40.
in FMA 950, what are you? 35 to 41?
Yes, 940.
And in the other one?
39 to 45.
39 to
45. FMA 939. So total land in question is 2.07 acre. In plot number 786. But out of 786, total plot is 2 acre. Only 0.919 acres was
acquired.
That means almost like 1 acre. Now, kindly consider total 2.2 acre as per the partition deed. Badrunnisa has the half portion, and other person have the half portion. So, Badrunnisa in 2.2 acre, she got 1 acre. But out of 1 acre, she sold the property to different person. The Chandan Bora, who is the appellant hearing, he purchased the property from persons from the vendor of Lokhi Mato and others. They purchased, if you also kindly see page 94 now. 94. That's third paragraph from the top.
Yes.
Muhammad Khan, being owner of the 50% of share, subjected plot, gifted his share to his wife, Badrunnisa Bibi, by registered being number so and so in the year 1973. That means Badrunnisa get 1.1 acre. Subsequently, Badrunnisa Bibi sold the property to Lokhi Mahato and Beri Mahato and Kulchan Mahato, so and so in various deeds thereafter, dated 1/6/1990. After that, said Lokhi Mahato and Beri Mahato appointed Santosh.
What was that date? 1/6?
1/6/1990. After the said Lokhi Mahato and Beri Mahato appointed Santosh Mukherjee and Hararan Shao as owner of the power of attorney and sold the property to Chandran Bora. Samuel Pandey and Shantanu Banerjee by registered deed number being so and so dated 4th November 2020, where out of 370, 347.5 decimal. So, but kindly consider total property purchased by Lokhi Mahato is 347.5. The property which was acquired is 0.919 acre, almost 100 decimal. So there are other properties sold by of these also, by this deed also. This is not that.
Chandan got 215.5 and rest of the two jointly got 132.
132.
Doesn't that add up to 347?
Out of 347, Chandan got 215 decimal. So it's required to look into the Chandan got how much property in respect of this plot of land. That was not gone into by the competent authority. Competent authority simply says total 347 decimal land was sold to Lokhi, that is the vendor of the Chandan, whereas the plot acquired is 0.919 out of 2 acres. 2 acres means 200 decimal.
Now, this writ petition was not filed by you. Writ petition was filed by Nanak Khan.
My property has been, my deed has been cancelled, nullified.
Understood. But you did not pay for any challenge against that.
No, since the writ petition has challenged the writ petition, I have supported it.
Does not mean that. If you have no independent challenge, the writ petitioners, if the writ petitioners do not have any locus standi, then you are gone. This is not an appeal where under order for 33 you can decide.
But that's true. But
That is the difficulty. It is an original proceeding.
original proceeding, but so far the civil court can guide it. So that-
Civil court could. What is the right of Nanak Khan? You have to support their right also. That
Now,
you have to show us that Muhammad Khan's sons had some right in the property.
But my why I'm
You have not preferred a challenge. You have delayed that at finality. They have challenged, and that too. What is your take on this competence of the competent authority?
not kindly consider.
We understand your first argument is that the rest portion was not decided at all.
At all.
You claim by virtue of also a title deed
Title deed
from Badrunnisa.
from Radhunisha, I purchased 0.33 acres.
So you had produced those deeds.
Yes, I have produced those deeds by the computer that it says since my
Yes.
deed was subsequent in 2005, not in 1990. So the Bandhanisa cannot sold that.
But you say that it was when she sold to this Lokhi, Besi and these people, some property was left out.
Some properties were left out. That was sold to me.
So this is incorrect. This finding.
This finding is incorrect.
Very good.
And firstly, my lord, only second thing as the point of law, my lord, I have
Yes,
heard-
point of law. What is your?
only one thing I will see.
Yes.
Section 3H. If we say one by one, first the determination of compensation. Not first the compensation determined. Section 3H1. 3H2 says the determined compensation will be deposited to the government before the competent authority. Now, my lord, the section 3H3 comes, whereby it says the competent authority shall decide who, in his opinion, are entitled to receive the amount payable to each of them. Now, my lord, if I say the competent authority's jurisdiction is to determine the persons who are entitled to receive the payment, then who will decide the apportionment? That has been not given.
Civil court.
3.4 says if any dispute arises as to apportionment of the amount, competent authorities jurisdiction 3H3 says only the persons who will receive the compensation.
That is the that is the main decision. Here that has been decided only this person.
Then if you go by the
Once it is held that X, suppose
X, Y, and
suppose
Z,
A to Z have applied.
Yes.
27 persons.
Yes.
Competent authority decides X and Y will get only.
Half and half.
Then thereafter the question of apportionment between them comes.
Yes, madam.
The rest of A to Y, yes, closed.
Madam, why I'm saying
That
so,
is the scheme.
why I'm saying so, why the 3A, why I'm supporting the law point is matter of the
How can it be otherwise? I mean, your question's answer is this. That entitlement will be decided, several persons are claiming.
entitlement
Authority
decided
decides who are entitled.
entitlement is decided in favor of X and Y.
Between them, apportionment
Half
can
and
come.
half. Then apportionment will come. But there is nothing has been lots of
Court does not say entitlement will be decided. That is a
the
difficulty.
decision will be regarding the apportionment.
Mr. Banerjee has rightly, it's a good argument, relied on the second limb. If any dispute arises as to not only apportionment or to any person to whom the same or any part
Yes.
thereof is payable.
Yes.
But as per the plain language, he was saying, Justice Tandon also says reconcile. It can be reconciled also by holding that this second person will be between the persons who have already been held by the competent authority to be entitled. That's also a way of reconciling.
That is also
Competent authority
yes.
holds X and Y or X, Y, Z. Then
apportionment
what
comes.
portion will be apportionment to X, what will be to Y and Z.
Z.
As to the person, civil court decides X will get, say, a little bit more than them because of the area which he has given up, something like that. So that is apparently the scheme. It can be reconciled by that manner also.
If we read harmonically,
Harmoniously, only we are doing that only.
then my lord,
One says entitlement, other says apportionment.
there is a comma between if any dispute arises as comma, then to the appointment of the
Yes, we are
apportionment,
disjuncting. We are reading, we are saying that to the apportionment of the amount to any person,
And
to
thereof
any part thereof goes. Now we directly read. If any dispute arises as to any person to whom the same or any person part thereof is payable, the competent authority shall refer the dispute to the decision of the civil court. We are taking it in that manner only. The apportionment part, leave it.
Now, if any dispute arises as to any person to whom the same or any part thereof is payable, now here comes in to whom the same or any part. What is that same? The amount.
Yes.
Same has to be given a meaning. So that obviously is the amount.
Not only amount is entitlement also, in my respectful sum. Same-
Entitlement, what are you saying? To any person to whom the same or any part thereof is payable. Entitlement is not payable, Mr. Ghosh. Only amounts are payable.
Yes, amount are payable.
So therefore, there can be a reconciliation because once the entitlement is decided under 3, only then the civil court will decide under 4. Let us forget civil court and competent authority.
Yes.
Whenever we bring that in our mind, we cannot reconcile because, as we said, it's a counterintuitive thing. We have learned the other way around throughout our lives, legal lives. Forget the authority. Suppose 3 was civil court and 4 was competent authority. Could you have made the same argument? Apart from the other argument of Mr. Banerjee, the basis that not judicially trained, that's a different argument. Suppose 3 said civil court and 4 said competent authority. Now then how can you have that argument even? Then 3 would read where several persons claim to be interested in the amount. The civil court shall determine the persons who in its opinion are entitled to receive the amount. Entitlement is different. Entitled to receive means ownership also. Entitlement to receive contemplates everything. Entitlement to receive is decided by the civil court. Then 4 says, if any dispute arises as to apportionment of the amount or dispute as to any person to whom the same or any part thereof is payable, the civil court shall, the competent authority shall decide. That would sound good to you. We are confusing because we are thinking civil court in civil court lines. Exchange the authority and see whether it can be reconciled. Where is the disharmony between these two? Where is the conflict between these two? The first authority under 3 decides the entitlement. Second authority decides apportionment or to whom what part is payable, which is between those persons who have been held to be entitled. That is the reconciliation which can be done. If you can reconcile, harmonize, then we cannot read down.
Yes. Maybe I'm wrong. But then what is the reason, I'm putting question to myself, what is the reason for insertion of this line? To any person to whom the same or any part thereof is payable.
Same or any part thereof can be reconciled in this manner. This any person to whom the same, this any person has to be read in the light of 3 then, who have been decided to be entitled. If 10% have been decided to be entitled, then the scope of the dispute, because it has to be read ejusdem generis also. Apportionment in the light of that, the previous portion of that section.
Yes.
It has to be read in the light of the words used in the previous part of the same section. Dispute arises as to what is the dispute. 10% is decided by the competent authority to be entitled. Now, among those 10, what will be the apportionment or to the person to whom the same, the amount or any part thereof, that entitlement has been decided. What part will be payable to whom, that it relates to apportionment also.
That's
or any part thereof is payable. That's difficult, very difficult.
Line is
That is one of the, if there is a possible interpretation by which we can harmonize, we cannot strike down, we cannot, and virus is not challenged, we cannot strike down also, or we cannot read down also. Reading down happens when reconciliation is only possible by way of reading down. Otherwise, as the learned single judge quite correctly held, if it's mutually destructive, reading down is the only way it can be done. But we don't find the mutual destructive. The concept, our notions are only on the civil code, on the authority. We are thinking in that line. Reverse the authority, then see whether it's irreconcilable.
Person to whom the same or any part thereof.
You can challenge the virus of this section by saying that a person having no judicial training should not be given this power. It should be reversed, which is a quite valid argument in a virus challenge.
That's my submission.
So you say, in line with Mr. Banerjee regarding the law, that this, like he said, any person, the same arguments actually. Any person is a different niche carved out.
Yes.
One. Secondly is that civil court is the general argument that civil court is judicially trained officer. So he should decide. That should be how we interpret this provision.
Yes.
And Justice Tandon's judgment also says it's somewhat.
And I showed to your lordship the
and that the entire part, that other part also, Mr. Shanal has to answer, that the competent authority holds.
Page 94.
Yes, page 94, right? That only 347.5 decimal, a part of Badrunissa's share was
transferred.
Lordship, it will be 1.3035 acre because total land is 2.07 acre.
Yes.
The Badrunisar part will be 100 decimal and odd.
Yes.
Badrunisar sold 347.5 decimal.
Hmm.
That means it include other plot also.
So then what remains for you?
No, but there are total 15 to 20 plots.
She had only this part.
No. Other parts also.
She had other parts.
Yes.
So that residuary might have been transferred to you. That was not considered while considering your deeds.
Because as per partition suit decree, not even thereafter the suit filed by my learned senior friend client, there are 10 plots and total area is 6.67 acres. So it is required to look
That
into
compromise suit.
the compromise suit. So it is required to look into the Badrunnisa sold how much property, how much portion.
That's on fact.
That's on fact.
Authority decided wrongly.
That's on fact. That is required to be decided by the competent authority before declaring my deed as null.
But learned single judge has delegated said that the matter should go to the civil court.
Civil court.
Decided on law only, not decided on facts.
No.
Set aside.
Set aside. Set aside.
Set aside.
Set aside and sent to the civil court.
Set aside on the ground of jurisdiction of the
Jurisdiction of
lack of jurisdiction, lack of competence of the competent authority. Very well. Yes. So, Mr. Chaudhary want to add something?
Yes.
Chaudhary, yes.
The deed executed by the Mahmud was not the gift deed, it was sale deed in favor of Badrunnisa in exchange of Den Mohor, first thing. Now, second, I am submitting Mr. Ghosh's client claiming title through a deed of 1985, which was executed by Mahmud Khan after transfer, not Badrunnisa. I handed over all documents before the court. There is a bunch of documents which were submitted before the court at the time of hearing of the writ petition. They will hand over when it is with them.
With whom?
With and copies were served upon all.
Yes.
And
Yes.
Deed
Got
number
Yes.
6, page 13 to 18. Group of Mahato.
Oh, this was Muhammad Khan.
Yes. Now,
all these documents were produced in the before the
yes,
competent.
yes, and copies were served upon them at the time of hearing of the writ petition also.
Achha.
All these branches. My next thing, I have short submissions. I am drawing
Mr. Chaudhary, you are appealing for which who?
10 and 11 Lokhi, who withdrew the suit.
But how do you deal with your admitting that you don't have title?
After transfer, kindly one thing. The case of the writ petitioner before the authority is this, that the Mahmud had title, Mahmud transferred to Badrunnisa, and Badrunnisa transferred to Lakhiberi, and thereafter they are saying ki the Lakhiberi withdraw the suit, so its title should be reverted back to Mahmud. How it can be, my lord? Title cannot be reverted back.
No, the suit was filed by Lokhi.
Lokhi, who purchased from Badrunnisa, and Badrunnisa purchased from Mahmud. Their case is this: since the suit has been withdrawn, title should go to the Mahmud. It is the case before the authority. Not only that, kindly come to page 53 of the appeal, stay petition.
But if Lokhi says no title, then you also don't have any title, Chandan, and not you.
I may be divert from filing suit. My title cannot go.
No, but you admit in that order it's recorded that Lokhi admits that Lokhi had no title, and this Chandan and this other person, they claim.
When it was after sale, not before sale. When sale was made.
After sale, they go and admit that we have no title.
Yes.
So therefore, acha.
Exactly. And one thing more, page 53 of the application. Page 53 of the application. And their case is this.
Right.
Title has been reverted to Muhammad. not the vendor of the Lakhi, vendor's vendor of the Lakhi.
That cannot be. You said that cannot be. It has to go back to Badrunis.
They have. Can you see the page 53? What is their prayer before the authority? Clause
53.
Last clause.
Your 53 of your bunch.
No, my lord, in the application.
In the application, yes.
Application.
Application 53. Oh, there are two sets of paginations. Yeah, page 53.
Not in the application.
Yes. Apportionment of award in respect of acquisition of land.
What is their claim? It has been reverted back to Mahmud and it should be given to us as per Mufti. And Mufti is not admissible in law, which I submitted a judgment before the trial court.
But certificate of Mufti cannot override sale deeds.
Yes.
Registered sale deed. Certificate of Mufti is on the basis of inheritance, succession. Nobody disputing, otherwise succession is all right. I mean, but if there's a registered sale deed, that prevails.
Yes.
Very well. Thank you, Mr. Chaudhary. Yes.
Now, I think your losses has now got the point. My lord, with all respect, my lord, Learned Single just simply followed the Supreme Court judgment. Should we go back to the civil court? What's the civil court to decide? Is there any dispute, my lord?
Ajay, we'll take one reply from Mr. Ghosh before we hear it. Mr. Ghosh, a new point has been raised by Mr. Chaudhary, which you must answer. Because these documents were produced, you claim title not through Lokhi, this Badrunnisa,
Yes,
but from Muhammad Khan.
That is recorded by the imputed order. That is recorded in the imputed order.
No, you are claiming through Muhammad Khan.
No, Badrunnisa in 2000.
Your deeds have been produced here by Mr. Chaudhary. These copies were given.
Deed of 2005. But property sold on lordship.
You are Umesh Mahato, Anadi Mahato, etc.
Adalat Mahato. It was sold to Kalipada Mahato and Nepal Gorai.
But sold by Muhammad Khan.
Kalipada Mahato and Muhammad.
Where are your sale deeds in this bunch? From Badrunnisa?
May I look into the branch?
There is no deed produced by Badrunnisa to you.
May I just?
Because somebody appeared on your behalf, Mr.
Yes.
Mr. Ghosh appeared.
Mr. Ghosh himself appeared?
No.
Before the writ court? No.
Before the writ court, I appeared.
Yes,
then bunch was given to you.
Oh, sorry.
Kindly see. The serial number 6.
Yes.
It's relating to Anadi Mahato and Srimati Mahato. They are the other persons.
Who are you?
My deed is not exhibited here.
You did not produce your deeds?
I produced the deed in the before the.
I've got copies of those deeds.
Right now, I don't have, but it has been recorded in the order, impugned order.
Impugned order of the single judge or the
competent authority as well as the single judge. If you also kindly see page 94. Page 94 of the competent authority.
It starts from 93, last paragraph.
Kindly come to page 94.
What are your name? Adalat
Mahato.
Where is the finding regarding you?
Just third paragraph.
Which page?
94.
94.
That is third paragraph from
yes,
the last.
Terms of claims of Adalat Mahato.
Name of Adalat Mahato, son of Dhari Mahato and 6 others at serial number 27 to 33. This is to state that their predecessor in interest, that is Kalipada Mahato and Nepal Gorai, purchased an area of 0.33 acre.
No, then Badrunita
over plot number so and so by registered deed numbers 2005, which cannot be considered at this stage. At Badrunisa Bibi sold her entire property to others prior to 2005. Number, that's why I showed to your lordship the paragraph third paragraph from the top. Muhammad Khan being so and so 50% share of the subject plot.
As from 3H3 adjudication, there is any appeal provided?
No,
there is no appeal.
No appeal provided. My case is that yes, absolutely right. Badrunnisa got 50% share in the 786 plot number. But from the order of the competent authority, there is nothing to show that out of 2.17 acre, that is 1 acre which is what's belong to Badrunnisa baby, are entirely sold to the Lokhi Mahato. Lokhi Mahato purchased 347 decimal. That is not the suit. That is not the plotting question. Plotting question is only 100 decimal. I have purchased 0.33 decimal. But my deed has been declared as almost nullified by the competent authority. That is my case. And Srimati Mahato and the Anadi Mahato.
But Badrunisa did not sell her entire share to Lakshmi and Besi and
not that. Badrunisa says only 347.5 decimal. Total plot is 6 acres.
No, she had 6 acres.
Total.
She did not have 6 acres. Whatever she had, she
has 50%.
Yes. That comes to 3 something.
300.
That was sold out.
That was sold out.
After that, how could she sell to you?
No, but kindly see, in various the 347.5 decimal. But she got, may I tell you what is the actual 6.67 acres. She got 6.67 acres.
Badrunisa got?
Yes. As per the plain, which was subsequently withdrawn. 6.67 acres. In 10 plot of land. Out of it, she sold 347.5 decimal. And from 347.5 decimal, Chandan Boral got 215.5 decimal and others 132 decimal.
Very good. Yes.
That's that.
Yes, Mr.
Sir.
Now, all that I wanted to submit before your lordships, that I go back to your lordships, that section 16.
So what about this finding that to Mr. Ghosh's client says that Badrunisa it was held 2005 days is subsequent, therefore by virtue of Badrunisa's transfer to Lakshmi and your vendors could not transfer. He says that only 300 something was transferred by Badrunisa, 3 point something, whereas she got 6 point something. So part was still there with her, retained by her. She did not sell her entire share to you, to your vendors. So she might very well have transferred some portion to Mr. Ghosh's client in 2005.
No, that's his case, your lordships.
That was not decided. Blanket fashion, in a blanket fashion, competent authority says since 2005, therefore subsequent, no title. Page 94, second.
I get your losses. I think your loss is 93 last paragraph and 94 from the bottom 4th paragraph.
Yes.
These are the 2 paragraphs your losses. So far, Mr. Ghosh is concerned.
Yes, yes.
Just a minute. Actually, right, I'm joining that. I only this factual part your lordships. Right now I am not ready. I'm frankly speaking. Right,
factual. The learned single judge did not go into the facts at all.
Nothing. See, only
on this ground. So if we uphold the learned single judge's ground on the question of law, that no, it had to be relegated to the district judge, then we do not interfere. It goes to the district judge for. But if you don't, if you say that no, competent authority had, then we have to relegate it to the learned single judge, saying that please decide on merits whether the competent authority was right or not. Because these questions were not addressed by the learned single judge at all.
Or one way, if your losses consider.
Or you can send it to the competent authority. That would say one forum.
But your losses give me a day's time. Factually I will check it. Frankly speaking, that
will give it as to be mentioned tomorrow. Just complete your
losses.
In the plain paragraph, if I also kindly look at it. Sir, এটা দেখুন প্রিন্টে লেখা আছে।
I will check it thoroughly. If I factually that's why I gave the 3 and that.
Plaint filed by Lokhi and Besi, their vendor.
Yes.
So they are bound by that. Yes.
Certainly. I was really from the morning on the point of law.
Then single judge decided that only.
That's only and that your losses on the face of it is this is a civil, so you go back. It's not that
No, but then why we are minded to send it to the learned single judge? Because then also you lose because we usurp a forum. Why we are saying this? On question of fact, the challenge was on several grounds, including the question of law.
If the learned judge, we hold that the learned judge was wrong in holding that competent authority did not have jurisdiction at all, it had jurisdiction, then they have thrown a composite challenge to the order of the competent authority. Then the learned single judge had to decide on merit whether the competent authority was right or not. We cannot just like that say then we have to act as a writ court, and the appellate court cannot act in intra-court appeal. We cannot
act as a writ court.
we cannot act as a writ court and say and find fault with the competent authority. To remand it to the competent authority after holding that he had jurisdiction, we have to find faults with the competent authority's order on merits, as per Mr. Ghosh's submission.
So far, if I'm not wrong,
Then we have to ask the learned single judge to decide on facts whether competent authority was right or not. The other component of the challenge.
competent authority's order was questioned by my learned friends.
Yes.
Probably they are not.
No, that they did not.
Factual. Now, all that, your lordships exercising all the, obviously it's a court of appeal.
Yes, but Mr. Banerjee's client did not have locus standi also. How do you, apart from that admission by them, independently you could not have any title?
Really, my lord, I considered his aspect only.
So if the writ petition is not maintainable, then Mr. Ghosh,
Exactly, my lord. I'm on broader aspect of law.
he is standing on the shoulders of Mr. Banerjee. There is no writ petition in that.
Find altogether, my learned friend's submissions was elaborated by the learned single judge, 3 pages. Not
Yes.
Mr. Ghosh's submissions, all that.
No, Mr. Ghosh's submission, he was devoted half a page. And it was held that he has a point or something like that.
That's your lordship, my lord. That's not without challenge. That's the point. And your lordships, my lord,
Writ court, we cannot say writ court is the original jurisdiction. So appellate court's powers are not there. A defendant who has not filed a suit,
has all the powers of the writ court.
we have. Writ court, we say that Mr. Ghosh could not be given the status of a challenger.
Exactly. That's your lordship.
That is what we are
That's
saying.
your
Mr. Ghosh is convinced on that also. Otherwise, because he's doing writ matters every day. But if you don't challenge in a writ petition, being a respondent in a writ petition, there is very little scope to challenge.
That's your, and I take your lordships will find that my lord,
3 and 4.
3 and
We are fed up with this provision.
that's your lordship. That's the bonding.
We are. So, should we put it as to be mentioned tomorrow for this factual aspect?
Factual. Just.
We'll do that.
Just.
The plainly আপনার শিডিউলে বলা আছে
That's না দেখে বলবো না, না দেখে বলবো।
Hard in part, full stop, although arguments are substantially concluded, comma, learned senior counsel appearing for the appellant seeks a day apostrophe accommodation to address the factual issues raised by learned counsel appearing for the respondent numbers 35 to 41 in FMA 950 of 2025, within bracket, respondent numbers 39 to 45 in FMA 939 of 2025. Bracket closed. Full stop. Accordingly, let the matter be listed tomorrow under the heading, listed in the common monthly list of September 2025 under the heading to be mentioned.
September কেন?
Don't appear, you avoid our court regularly, Mr. Channel. How will you know?
Always love to appear.
Love to avoid.
No, when your lordships pointed out order 23, I said this is the right court. Why, my lord? We are allowed to argue, my lord, only. Whether Jews are right, that's different issue, my lord.
No, that's
Always.
all of you have crossed that stage. Loser. Yes. So we'll call the next.
I'm taking a lordships leave.
Please. Yes. Yes, Mr. Mukherjee, what is your?
But, an application was filed by the father.
Yes, Mr. Aniruddha Chatterjee is for the other side in that matter.
Application under section 17 of the Guardians and Wards Act was filed, my lord.
Yes.
Credit section 6 of the Adoption and Maintenance Act.
You are the mother.
I'm for the mother, my lord. Father filed the application in the year 2016.
Application was for custody as well as guardianship. The usual application under guardianship.
Usual. And custody.
One last question before you proceed. Was any interim visitation right asked for or given in that in connection with the
Which was given,
interim visitation was given. Where?
father was given the interim visitation right, child was with the mother. Child was born in the year 2010 and all along he is with his mother-in-law. And
Child is a son.
son
Yes.
studying in class 10, supposed to appear in Madhyamik this year not. And he is now aged about 15 and a half.
Yes.
This application was filed in the year 2016. And after that, the final judgment was passed on 26th June. And the custody was now given to the father. Challenging that order, Lord, we have come up before your Lordship, Lord. Our main contention is that Lord, the welfare of the child was not at all considered. by the Thane trial judge.
Mr. Mukherjee, you are the mother.
Yes.
Custody has been given to the father. Totally.
Mother was given the visitation.
What is there is no matrimonial suit between you?
Yes, Lord.
There is a suit.
There is
Who filed the suit and what is the fate of
has been filed
by?
by the husband. And we filed an application.
When was the suit filed?
The suit has been filed not.
Now, what is the stage of the suit? That's still pending.
Pending. It is pending. We filed an application under section 12 not.
Section 12. That must be in the Guardianship Act 8 case.
Yes, ma'am.
There it has to be section 26.
Section 26 was not filed.
Not filed. So divorce suit is pending. We'll rest it at that. But child, you say, was all along with the mother.
All along with the mother. Since birth and till now, till this day. And the child was never asked to be present, to be produced before the learned court.
No interview of the child taken.
Interview of the child taken.
This order has been implemented.
No, not yet. It's been directed to state.
Directing, but the appellant are not
You have got a police help order.
Yes, sir. But the police on the several occasions visited their premises, but the mother along with the
Mr. Chatterjee was there when the police help order was passed. He was not there.
On the same order, Lord.
Yes.
On the same order, not later on.
Oh, in this order, it has been granted. Police.
There were
Then who could not
reasons-
have been there.
There were reasons behind them.
No, that we are not prejudiced with that. But police help we are prejudiced with.
Yes, yes, Miller,
Any stay of operation has been.
yesterday, Miller,
This is for stay. So we'll grant stay of this operation of the.
Miller,
All along with the mother, Mr. Chatterjee.
the father will have no rights, Miller. May I
No, right of visitation will consider.
Is there? He is not given
Whatever,
to the child.
Mr. Chatterjee, whatever visitation you had in the trial court because you learned.
She's not given me anything.
No,
For the
we'll
past
ensure,
20
we'll make it a
years,
condition of this stay.
And she has taken away the child from the jurisdiction of the court to somewhere else. Even the address has been changed. I don't even know, Miller.
Police is all along running after this, Lord. And the police has even prevented the child from appearing for the test examination in Madhyamik.
Police help is not something, Miller, which I am going to, Miller, in any way.
Police is running after us, Lord.
No,
Even
running
though-
after that doesn't mean that you don't give the father access.
No, we are ready to give access, Lord.
It's been the submission all along.
What can be a possible visitation? What was the visitation he was directed in the court below, which he says you did not comply?
Visitation, he was going to the evidence is there not that he used to go to the residence of the respondent, Lord. There
So
is-
why was the custody given?
And thereafter, Lord, the father could not go. And after that, he used to visit the child through virtual means, Lord.
That also was stopped.
So
That also was stopped.
That was never stopped. There is
Milord,
no
it's,
such
it's,
allegation.
I would say, Milord, if it commends to your lordship, my lord, if your lordship has an interview with all three of them together, so that this, Milord, I do not take this as an adversarial
All
litigation
three,
at all.
Mr. Chatterjee,
Child is
we,
to be
we don't have any skill in that at all. We can have an interview with the child at best. 15 and a half is
Milord, the
intelligent.
child will
preparation.
always be, Milord, tutored because it
15 and a half is sufficiently intelligent.
then kindly talks to the child also.
He was never interviewed while passing the impugn order.
because of the conduct. My lord, if your lordship sees
Whatever may be the conduct of the parties, the child has to be interviewed.
Child
yes, yes.
contact was
No,
not
I am not. I'm.
Custody is 15 and
I
a half
would
years
say-
is residing with the mother.
Sir,
Custody is given to you.
That's because of the, my lord, the entire. If your lordship sees the order, the conduct of the mother and the way she is done, my lord, there is a
We
concept
threaten
of-
that. We threaten, issue those threats on YouTube also. But we don't do it actually.
The problem
Just
is,
because she is not honoring the
there's
visitation right.
there's a thing called shared parenting. The child is entitled to, my lord, the benefits of both the father and the mother.
Undoubtedly, who doubts that?
Then once she does something, my lord, which is for not for the benefit of the child, the court has enough experience or powers, my lord, to put its foot down.
Paramount considers the interest of the child.
Absolutely. I bow down.
Interest of the
My
child.
lord, there is, my lord, a father has a
Only
role to
parties
play.
recalcitrance does not enter.
The father has a role to play. The mother has a role to play.
Mr. Chatterjee, we can will stay the order operation of the order. There cannot be police help and there cannot be custody to the mother immediately, subject to visitation rights which we will be granting. What can be the contours of visitation? If you can
Your lordship
agree,
does that, then
we'll
I
give you
will
2
take-
days. I mean, come back on Tuesday. We'll give you Tuesday. Come back on Tuesday. We'll grant that stay right now.
Lord,
Stay of operation for a limited
nothing
period.
has happened in the meantime.
No. We don't know.
Nothing has happened in
The stay of operation, they have made out sufficient ground for stay. But that stay will be for a very limited period. You come back on Tuesday.
There's one very important aspect in
Yes.
this matter. My lord, we have, because of stay, my lord, we have spoken to the headmaster of the school where he's supposed to go. The police also went there. The school child is not going to the school.
Whatever.
going, Lord, in
We'll
the
direct you
school
to file
property
affidavit
for
in
pushing
opposition
the
to this
child.
application. You can file an affidavit in opposition to this application
The
or
visitation-
independent visitation right.
Visitation immediately, my lord. I'll just gives me 1 day's time. May I come back tomorrow and tell your lordship?
Tomorrow we have a single each of
After
us
2 minutes. In the morning.
throughout the day. Morning original side, afternoon appellate side, assigned matters
Then
in
allow
both
us to
sides.
come back on Tuesday. I'll come back on Tuesday and tell your lordship what would be a feasible thing.
No. Have a talk with him also.
Yes,
in
yes.
between, so that
Mr.
have an
Modi-
interaction between your client. I mean, between yourselves upon taking instruction from your clients, and if you can agree to a visitation place and time, we can think about that as a
But he's
condition of this
15
stay.
years old. It's not that he can always be tutored. He can always be.
15 and a half is
Yes,
sufficiently
he's
intelligent.
not always. He's probably
Before
class 10.
disposing of this matter, finally, we may have an interview with the child also.
Yes.
But at this stage, maybe
So what
not.
I was
Unnecessarily calling him and all.
What I was also praying is
Yes, Mr.
that
Chair.
lordship, my lord, all the papers are on record. Your lordship gives us, my lord, an hour's time and hears out the appeal itself.
Not possibly before the vacation. There are several other matters. So many applications.
Just after the vacation, maybe, my lord, if it commences.
We can do that. We can do that.
Keeps it, my lord. May I make this?
We'll
submission?
pass a stay order right now.
Keeps it on Tuesday, passes it, my lord, or every, and I assure you, I'm not going to do anything, my lord, in the meantime.
No. We'll pass a stay order right now, but for a limited period. We'll keep it on Tuesday.
Keeps it on Tuesday. I'll come back, my lord, with whatever.
Learned Senior Counsel appearing for the appellant argues that the child, whose custody have been given by the impugned order to the respondent father was all along residing with the appellant mother for about 15 and a half of his 15 and a half years of his entire lifespan. Next para, secondly, in the impugned order itself, simultaneously with granting custody, police help has been directed to implement the order, which is rather absurd in a
There's a
custody
weird
matter.
thing. What has happened here is that she's remarried and has another child. But that doesn't mean that she can't love the.
No,
first
we'll record that also. Thirdly, it is argued that the learned trial judge did not have an interview with the child, who is of the age to form intelligent preference, prior to granting custody, guardianship, granting custody to the respondent father. Next para, learned Senior Counsel appearing for the respondent controverts all the allegations and submits that the recalcitrant attitude of the appellant mother in not complying with the visitation orders passed by the trial court was one of the considerations for granting custody as well as police help in the impugned order. Next para, that apart, it is insinuated that the child may be tutored by the appellant mother, in whose custody the child is at present. Next para, learned Senior Counsel for the respondent reserves his rights to argue further. At this juncture, it transpires that the learned trial judge had passed visitation orders during pendency of the matter, and it is during pendency of the Act 8 case, Act 8, 8 Roman, Act 8 case, and it is disputed as to whether such order was complied with, and if not, why. Full stop. Next para. On the request of the court, learned counsel for the parties agreed to have a talk with their clients to ascertain whether there can be any common venue and schedule of visitation of the child by the respondent father. In the meantime, full stop. Next para. For such purpose, let the matter stand adjourned till September 2, 2025, when it will be listed under the heading application. Full stop. Next para. The operation, in view of a sufficiently strong prima facie case for hearing of the appeal on merits having been made out, the operation of the impugned order is stayed till September 15, 2025, or until further order, whichever is earlier. You come with something concrete, and we'll maybe deciding the application on September 2nd and putting the appeal immediately after the vacation.
I'm great.
Well, may I trouble you, Lordship? The next matter is mine.
Yes.
At 2 o'clock, I'm in some difficulty.
Mr. Shah, just ask somebody to ask for time.
Right, I will do that.
And
Yes.
just please ask him to also tell your other side.
Yes, yes, my lord, I will.
Right.
Yes.
Ramji.
You have Mr. Shah is for the?
Yes, my lord. For the respondent, award holder.
On the prayer of the respondent, the matter is adjourned for the day.
Tomorrow?
Day means Monday. Tomorrow you sit singly.
Yes, Monday. Monday or something. Obliged. Request if it can be done on Monday or Tuesday. My lord, he was here throughout, my lord, Mr. Shah. Only second half today he had a my lord, he's here. We've taken specific instruction on that. He's here on Monday. He's here. Shouldn't be.
I am for the respondent.
This one.
That the state has filed the application for review. Number only one point why he has concluded.
Mr. Sengupta had finished probably.
Yes, he has finished.
You are also argued. Yes.
No, I have not argued.
You have not.
Because I have not studied argument.
No, you said you will argue. Yes, right.
Yes, yes. Because of this reason, this is a review. Now, my lord, your lordships has seen, my lord.
Scope is otherwise limited.
Scope is otherwise nothing to interfere with because there is no apparent error on the face of the award. Your lordship knows several judgments are there. But what they intend to say that again, my lord, like yesterday I have compared, my lord, that vesting under section 4(1)A will continue. I say, my lord, the vesting under the Act 2 will not continue. I wanted to cite some judgments with notes that my lord, I have brought, and my lord, that is the.
Just
এক minute.
My lord, before my lord, because I have already completed.
Yes, you have.
But my lord, kindly allow me for a few minutes so that I make my learned senior friend to understand what I intend to make what is my submission. My lord, my first submission was that my lord has already taken note of it. That Order 41, Rule 22 explanation is very clear that unless the point is taken in the reference case, in the appeal court, you cannot take this point. One. Number two, that my lord's judgment primarily based on it is a void one. So their appeal succeeded, my appeal fails. So my lord, there I join issue that my lord need not go into the argument regarding my lord knows that one is void ab initio, another is I have the authority, but my judgment which was under the challenge that may be called an illegality. Void ab initio, my lord knows that from the very beginning, I have got no jurisdiction. Void means void ab initio, that my lord knows that, and my lord was kind enough to mention and make an observation for which I have searched another judgment, and my lord knows that judgment. I want to cite that regarding what is void, what is voidable, what is irregularity, what is arbitrary. But my lord, only thing, my lord, that void is something else. My lord can take this point if it is without jurisdiction. It is a nullity. Hey, from the very beginning, it is without jurisdiction. So, my lord, I am giving one example, my lord. In so many statutes, there is a bar. Even the point cannot be taken, or it was not taken in the trial court, first appellate court, even in the Supreme Court, that point can, if it is a pure question of law. But my respectful submission is that this is not a void one. Not void, because at that point of time, when as per the statute, regarding passing of the award by the district collector, that provision is there. But my lord held that the order is a void one because it was passed after 2 years. So my lord, not that it has got no jurisdiction, but it is, yes, it can be set aside. It can be set aside. Even a void degree has to be set aside. Unless it is set aside, it is binding upon the party. That is the law, Supreme Court judgment. And my lord, if it is not a void one, if it is a void of event, that has to be challenged. My lord, my humble submission before my lord, that first of all, it is a mix. It is not a void ab initio. It is a mixed question of fact and law. And mixed question of fact and law has not been stated in the mother, that is the reference case. Only they are aggrieved with the lower amount. That's why they are sought for seeking enhancement of that amount. So for the reference case. Now appeal, he cannot brought up this point afresh unless if my lord decides, Mr. Sengupta, if in my lord's judgment, if it is a void one means at the beginning you have no power. Or there is a prohibition, you have got no authority to decide that question. But here is a mixed question of fact and law. Here, even if the point is taken for the first time in the appeal, there is a statement that the collector passed this order after expiry of the statutory period as mentioned in the statute. So it is at best, it is an irregularity, illegality, arbitrary. And that has to be set aside in a competent court of law. And competent court of law is the forum, competent, or I may say otherwise, in other words, is a competent forum means learned LA judge. Because LA judge has every right to decide any question of law. Now, my lord, I am referring, regarding void, my lord, I am referring 2006 10 SCC. Sir. Regarding void and my lord, it is absolutely, my lord, this is the judgment, my lord. My lord, after that, there is no such judgment relating to such clearness of regarding what is void. My lord, clearly it is a question, my lord. Kindly come to page, first, my lord, paragraph 95. Whether, and my lord, it was decided that jurisdictional error, whether the distinctions, fine distinction between the void one and the irregularity, arbitrary or voidable, whether that has been completely wiped out or still remains. My lord, kindly come to first paragraph 95. Perverseness in connection with the finding of fact is an aspect of mistake of law. My lord, here, at best, it is a perverse. But it has to be challenged in a proper forum. And he missed that opportunity. It is not a pure question of law that can be agitated at any point of time. Now, my lord, kindly come to paragraph 96. Opinions may differ as to when it can be said that the public law domain, the entire proceeding before the appropriate authority is illegal and without jurisdiction, or the defect or infirmity in the order goes to the root of the matter and makes it in law invalid or void. But the matter may have to be considered in the light of the provision of the particular statute in question. My lord has read the statute, because not that it has dubious jurisdiction before entertaining that. But my lord, at best it is a perverse. It is difficult to visualize situation hypothetically and provide an answer. Be that as it may, the question that frequency arises for consideration is, in what situation and cases the non-compliance or an error or mistake committed by the statutory authority or tribunal makes the decision rendered ultra-vires or a nullity or one without jurisdiction. If the decision is without jurisdiction, notwithstanding the provision for obtaining reliefs contained in the Act, and the ouster clauses, the jurisdiction of the ordinary court is not excluded. So the matter assumes significance. Since the landmark of the decision is, my lord already knows, my lord, because pausing here for a moment, section 9, my lord knows that, CPC, my lord, unless there is an implied restriction or expressly provision that lower court jurisdiction expressly barred. On the contrary, learned LA judge has got the power of the court, competent court. There is a competent court to decide any question of law. It was not taken into that forum. Well, kindly see. Matter as since the landmark decision in Anismanic Limited versus Foreign Compensation Commission, legal world seems to have accepted that any jurisdictional error, as understood in the liberal or moral approach laid down therein, makes a decision ultraverse or a nullity or without jurisdiction, and the ouster clauses are construed restrictively. And such provision, whatever their stringent language be, have been held not to prevent a challenge on the ground that the decision is ultraverse and being a complete nullity. It is not a decision within the meaning of the Act. The concept of jurisdiction has acquired new dimension. Original or pure theory of jurisdiction means authority to decide, and that it is determinable at the time of commencement and not at the conclusion of the inquiry. The said approach has been given a go-by in Anismanic case, as we shall see from the discussion herein after. Well, kindly see, a tribunal must not only have the jurisdiction at the outset, but must retain it uninterrupted until it has discharged its tax. So, even Anismanic case is to be applied here, tribunal is not without jurisdiction. Collector has got no jurisdiction or is without jurisdiction to entertain and pass an order. Kindly see. This is the best decision I have ever seen because I have taken regarding this searching, my lord. I have only find out this decision will help us. That is me for my learning, not my lord. My lord, because the kind see. Tribunal must not only have jurisdiction but must retain it unimpaired until it has discharged its tax. There is no provision in the Act that once you entertain, you cannot decide that within the statutory period. If it is there, it is barred. That statute never says. 11A says, says that if it is passed within if it is passed beyond the statute 2 years or 3 years, then it has to be declared as an arbitrary one at best, not a void ab initio, but because it doesn't lack the jurisdiction or ouster of jurisdiction. Kindly see. The decision in Anismanic has been cited with approval in number of cases by the court. Now kindly come to paragraph 12. It was the word jurisdiction is a verbal coat of many colors. Jurisdiction originally seems to have had the meaning with the Lord Reed ascribed to it Anismanic and Foreign Compensation Commission, namely entitlement to enter upon the inquiry in question. If there was an entitlement to enter upon an inquiry into the question, then any subsequent error could only be regarded as an error within the jurisdiction. The best known formulation of this theory is that made by the Lord Darman in R versus Bolton. He said the question of jurisdiction determinable at the commencement, not at the conclusion of the inquiry. In Anismanic, but there are many cases. Kindly see. It has explained how to, my lord, where although the tribunal had jurisdiction to enter on the inquiry, it has done or failed to do something in the course of inquiry which is of such nature that the decision is a nullity. It may have given this decision in bad faith. It may have made a decision which had no power to make. It may have failed in course of the inquiry to comply with the requirements of the natural justice. It may have in perfect good faith may have misconstrued the provisions given it power to act so that it failed to deal with the question remitted to it and decided some question which was not remitted to it. It may have refused to take into account something which is required to take into account, or it may have based its decision on some matter which under the provision of setting it up, it had no right to take into account. I do not intend this list to be exhaustive. Now, kindly, Lord, lack of jurisdiction may arise in various ways. There may be an absence of those formalities or things which are conditioned precedent to the tribunal having any jurisdiction to embark on an inquiry. Or the tribunal may at the end make an order it has no jurisdiction to make. Or in the intervening stage which engaged on a proper inquiry, tribunal may depart from the rules of natural justice, or it may ask itself the wrong question. or it may take into account matters which is not directed to account, thereby it would step outside his jurisdiction. It would turn his inquiry into something not directed by the parliament and fail to make the inquiry which parliament did direct. Any of these things would cause this purported decision to be a nullity. Dicta majority, my lord, in the House of Lords. In the above case, my lord, I am just within, my lord, kindly see the effect, my lord, just 3 lines from top. It starts with the effect of dicta. My lord, got it? In that case, is to reduce the difference between the jurisdictional error and the error of law within jurisdiction almost to a vanishing point. Almost to a, kindly see. Then the practical effect of the decision is that any error of law can be reckoned as jurisdictional. This comes perilously close to saying there is a jurisdiction if the decision is right in law, but none if it is wrong. Almost any misconstruction of statutes can be represented as a basin, their decision or in a matter which they have no right to deal. Imposing an unwarranted condition or addressing themselves to be a wrong question. Majority opinion in the case leaves out a tribunal with virtually no margin of legal error. Where there is an excess of jurisdiction, merely error within jurisdiction can be determined only by construing empowering statute, which will give title guidance. It is really a question of how much latitude the court is prepared to allow. Then, though the dividing line, subsequent constitutional bench, though the dividing line between lack of jurisdictional power and erroneous exercise of it has become thin with decision of the House of Lords in Anismini case. However, the Anismini-led Foreign Compensation Commission, we do not think that the distinction between the two has been completely wiped out. We are aware of the difficulty in formulating an exhaustive rule to tell when there is a lack of power and when there is an erroneous exercise of it. The difficulty has arisen because the word jurisdiction is an expression which is used in variety of senses and takes its color from the context. Whereas a pure theory of jurisdiction reduces the jurisdictional control to the vanishing point. Adoption of a narrow meaning might result in a more useful legal concept, even though formal structural law may lose something of its logical summary. At the bottom, the problem of defining the concept of jurisdiction for the purpose of judicial law has been one of the public policy rather than one of logic. Then, my lord, kindly come to next paragraph, my lord. Starts with page 100. Well, I just 100. Then, my lord, then the kindly turn the page. Page 100. It starts with. My lord, I am showing the only paragraph 100. Sorry. I stand correct. It should be such and such. It should be noted in recall. Thus, in the case, Anismenic principle was held to be inapplicable in a case of superior court when the decision of the case is made final and conclusive. Only in suppose, my lord, the High Court and the my lord Supreme Court passed an order. But here, this is not the same, my lord. Now, my lord, kindly see. Authors have discussed the pure theory of the innovative decision in Anismenic case. The development of law is post-Anismenic period. The scope of finality clauses, exclusion of jurisdiction in the statutes have laid down a few proposition 256, which could be advanced on the subject. Authors have concluded the discussion as page 25, page 256. After Anismenic, virtually every area of law is jurisdictional, and the only place for non-jurisdictional is where the components of the decision made by the inferiority include matters of fact and policy as a law, and where the error was evidential. Lord Diplock, when he suggested the tribunal is entitled to make an error when the matters involves has been a due interpreted question of law, fact, and degree. Thus, it was for the county court judge in Parliament to decide whether the installation of central heating in a dwelling house structure, alteration, extension, addition. This was a typical question of mixed law, fact, and degree, with only a schoolish to think it appropriate to dissent in separate questions. So, my lord, sum and substance of the argument would be, my lord, with my all respect to my lords, and humility, my lord, that this is my submission, humble submission, not, my lord, after all, my lord will decide. My lord, this is a thing My lord, it was not decided in any of the court of law. 7, except I got it that what is without jurisdiction and what is jurisdiction, but within jurisdiction it has committed an error. So if it is, my lord comes to a conclusion in that, yes, it is not a void ab initio, then everything goes, then my appeal would be the review application would be allowed. This is my response. I think, my lord, no other decision could suffice the purpose. But subject to my lord's again kindly. And that should be a law laid down. Well, this if I may lose, or that is not the factor. I want a judgment from the honorable bench. May I take a class?
এটা না
দিয়ে দিলাম তো আপনাকে।
আমারটা আমি যেটা আজকে ফাইল করছি আনরিপোর্টেড গুলো দিয়ে দিলাম।
ও আনরিপোর্টেড, এখানে তো আমি তো অন্য জায়গায় গেছি। আপনি দেন না,
আপনার জজ সাহেবকে এই দুটো দিয়ে দিন। On the first day, today different aspects has been argued, no problem. That we will answer later on. First point of argument, first, your lordships, so far as the scope of review is concerned, I need not cite any authority, although I have cited. Regarding review of any order, the settled position, there must be an apparent error on the face of the order.
Yes.
It has not been pointed out as yet what is the apparent error on the face of the award. That has not been shown to your lordship. Only thing he wanted to say by saying, first point was that this compensation could not be decided under 2013 Act. At best, this ought to have been decided under the Land Acquisition Act. He relied upon 2 pages or 3 pages judgment of Shaktipada Chaudhary. Your lordships kindly see that.
Yes.
That was the first point. And the second point was argued was that the once the property vested absolutely, it does not divest. These are the 2 points, my lord, I want to answer your lordships. I have given the very short notes.
Yes.
My lord, I have not, my lord, in the first case, my lord, I have given the note kindly with all reference to paragraphs. My lord, kindly come to, I have given chronologically according to my reference. I have given kindly come to first judgment, my lord, 2002 CHN 108. First judgment, Savitri Devi.
Yes.
Now, kindly come to para 31. Prior to para 31, in paragraph 27 and onwards, this court, this honorable single judge, discussed what is the scope of vesting under the Land Acquisition Act. Sorry, not scope, what is the distinction between vesting under section 16 and 17 of the Land Acquisition Act, and what is the vesting under 4(1)(a) of the Land Acquisition Act. This distinction has been clearly made in paragraph 27 and onwards. That's why I do not want to trouble your lordship placing all those. Kindly come to para 31. Therefore, the principle of exception to 11(a) of 1894 Act is not applicable in such case. As such, this expiry of time provided in section 7, this was decided in the context of 7(a). 7(a) of the 1948 Act results in the lapse of the notice under section 4(1)(a) of that Act. This again is to be considered having regard to the 48 Act, that the 1948 Act, a temporary status to defest. Then that the vesting therefore cannot continue on the lapse of the notice under section 4(1)(a). This is the clear finding. Now, this was an appeal was preferred. Now, because of different interpretation of 2 division bench, the matter went on to special bench. Now, kindly come to the regarding lapsing of the notice. Kindly come to next judgment, 2011 3 CHN Cal 555. Kindly only come to para 19 and 20. Finding regarding the lapses of notice under section 4(1)(a). Para 19 and 20. Everything has been considered here. Ultimately, it was held
Yes.
Thus, the effect of the Land Acquisition West Bengal Amendment Act 1997, which came into operation on the midnight between 31st March 1997 and 1st April 1997, prevented all those notices under Section 1A, subsection 1A of Section 4 issued after April 11, 1994, from being lapsed by giving scope of revival by way of a notice under Section 3B of Section 9 of the said Act, if the award has not been passed within 3 years from the date of publication of such notice, which would otherwise lapse if the said award of 1997 would not come into operation at the midnight of 31st March 1997. However, in respect of those notices under Section 1A of Section 4, which were issued prior to March 31, 1992, and in respect of which award has been passed by 31st March 1997, those notices are already lapsed, and by the amendment of 1997 and the Land Acquisition Act, the West Bengal Legislature, no provision has been made for revival of the lapse notices, which stood lapse already on 31st March 1997 for non-compliance of the provision of Amendment Act of 1996. By the Amendment Act of 1997, only those notices under Section 1A of Section 4, which would have lapsed on the midnight of 31st March 1997 on subsequent date have been said. But all those acts, my lord, I have given when I argued this. This is the position. Then, my lord, this went on to Supreme Court. But kindly next order, that is not the judgment, that is Supreme Court. Kindly come to Supreme Court. This is covered by this. In Lakshmani's case, we, along with other 4 appeals were heard. This last paragraph I am reading from the first page. Since the matter has been pending in this court, I am not going to theory of merger, etc. The impugned order has not been complied with. Since we do not find any ground to interfere with the, we direct that in terms of the impugned judgment determination of the market value as on 18th of March 1999 be made within 2 months from the today by way of supplementary award. Payment is terms of the award so made may also be made simultaneously with the making of the award. So the what happened in the first Savitri Devi's case, consequently 2 notices were issued. First 9(3) notice was given, then they thought, my lord, the valuation will be much more. Then they wanted to revive the lapse notice. Second notice was given. At that time, my lord, the first proviso of 9(3)B was challenging the petition, that is ultra vires. This court interpreted by applying principle of reading down your lawsuit, etc. Ultimately held that some notices are valid, some notices are not valid. But since in the Savitri Devi's case, first notice was issued on 18th of March 1999, High Court directed, at that time it was passed, the judgment was passed in 2002. Only no right to fair compensation, no, only Land Acquisition Act was running along with the amendment of 1997. So this court directed you determine the compensation as on 18th of March. So as special case, Supreme Court directed you determine the compensation as directed by the trial court. So what I am saying, this vesting did not continue as has been held by, has not been touched by anybody. Has not been touched by anybody. This is the first. Second, my lord, that I have said, my lord, last.
So we don't get your point. Why do you cite this?
My lord,
on what? Why are you citing this?
This Supreme Court.
No, Savitri.
Savitri, I say that the vesting under paragraph 31, vesting under section 401A did not continue after notice of under section. That is the principle I have noted down. Paragraph 31 in my note.
Yes.
It has been held that the vesting under section 401A 1948 cannot continue on the lapse of the notice under section 401A of 1948. On this principle, I am saying, but they are saying regarding vesting, para 31 of Savitri Devi judgment. For the contention is this.
No, and regarding this Lokhipan?
Lokhipan
is Savitri same.
Savitri Devi, that was went to Supreme Court, it has been appealed by Supreme Court. And the division special bench, it has also dismissed the appeal. It has been, my lord, the judgment has been affirmed.
No.
In special bench,
Savitri Devi, no, the special bench,
yes,
Justice Bhattacharya's bench,
yes,
that was in the matter of Savitri Devi.
But your lordship, 4 appeals were heard.
Lokshiranipan is the same.
No, Lokshiranipan is a different case.
Different case, yes.
Different case. What I am saying,
yes.
Kindly see 2011 3 CHN, 4 cases are there. kindly come to page 2 of the special bench judgment.
Yes.
FMA, this state of West Bengal, Sobita Mondal.
Right.
Then state of West Bengal, second one FMA is state of West Bengal, Savitri Devi. Then Milord other state of West Bengal, Nur Islam. Then Milord Samir Kumar Das versus state of West Bengal.
No, but this 19 says 97 of 1997 amendment prevented all those notices under subsection 1 from being lapsed.
Yeah.
19, paragraph 19 of the special bench says,
yes,
para 19,
yes,
that the effect of Land Acquisition Act 90, Amendment Act 97
yes,
prevented all those notices under subsection 1A of section 4 from being lapsed by giving scope of revival by way of a notice under subsection 3B.
Yes, Milord, once again I am reading. Thus, the effect of the Land Acquisition Act West Bengal 1997, which came into operation on the midnight between 31st March 1997 and 1st April 1997, prevented all those notices under section 4(1)(a) issued after April 1, 1994 from being lapsed.
Right.
By giving issued after first April by giving scope of revival by way of notice under section 3B of section 9. So, Milord, this is prevented from release, which means that the notices which were issued after 31st March 1994, 1st April 1994.
Those were saved only.
Those were, Milord, in those cases, you can apply 93B. You can, this means you can apply 93B for revival of the proceeding and can pass the award accordingly. The meaning of this is this. That means question in the Savitri Devi's case, main question was if the notice lapses, can 93B be applied?
So you see paragraph 20 squarely applies here.
Yes. No, actually it's a big judgment. Main question was that if a notice stood lapsed by operation of law, then you serve a notice under section 93B for declaration of, suppose a notice is published in 1980. Then in order to complete the acquisition proceeding, you apply 93B and say that the assessment of compensation will be done in 1980.
There are two types of lapsing.
Yes.
One is by virtue of operation of a new statute.
Yes.
The other is by virtue of the time limit that period provided in the previous statute.
Yes, in 1996 7A.
Yes, but the judgment cited by them, you are saying that saved probably from operation of law, lapsing by operation of law was saved by saying that no, compensation can be granted under the new act and all these things, all those propositions. But lapsing under the timeline provided in the previous, that was not saved.
That was not saved.
Two types of lapsing.
Yes, two types of lapsing.
So
another example I am giving you to yourself. Suppose a notification is published on it expires on 31st March 1997. 31st March 1997.
Yes.
Then notice is published November 1996.
Right.
Then their notice is saved. You can go to the 90.
That's within the time.
Yes,
in the first
that
place.
is within the time. So
merely by operation of a new statute, it does not lapse. That is what was it.
That has been decided.
But it has to be within time otherwise.
Yes. So, Milord, the Savitri Devi's case has, if your lordships kindly see, Milord, that has been clearly explained in Savitri Devi's case.
Yes.
What type of notices under saved?
In fact, the very first head note says that.
Yes. What type?
Italics head note.
What type of notice is saved?
If you see the very first page of Savitri Devi,
yes,
not paragraph 1, the first head note.
Yes.
A notice issued under 4(1)(a) of Act 2 of 48 shall stand lapsed unless award is made within 3 years from the date of publication if issued after 1st April.
Yes. Or within 1 year from 1st April if issued 2 years before 1st April 1990.
That is not saved.
That is not saved. That is the judgment, and that has also been explained.
Where not lapsed by reason of section 7A, then the other question arises.
Milord, your lordships will yes, that is not saved. Milord, your lordships will kindly pardon me, Milord. It may be that justice special bench judgment has been enclosed along with this, Milord, by mistake. Milord, last Milord, it has been enclosed. Possibly that's my mistake.
Along with what?
Along with this Savitri Devi's judgment,
Yes.
special bench judgment has also been annexed. Has been
No,
annexed.
no. Separately given to us.
Separately given.
Yes.
But possibly it is there. It may be, it may be there, it may be double, it may be. But whatever is it.
No. We have only this.
Yes.
Only. Oh, acha, yes. You're right.
No, it was in a bundle. So
Double.
when it was Xerox, kindly.
So we can return one Xerox to you.
The lordships can keep it or return, no problem.
Return it, yes. It affects.
But by mistakes, my lord, I ought to have done that, but I have failed to check it. So, my lord,
No difficulty at all.
So, my lord, the sum and substance of the three judgment is this. Then in Savitri Devi it was held 4-1A. After lapsing of 4-1A, other things are there regarding declaration by award. In addition to that, it was held distinguishing the vesting under Act 1 and vesting under Act 2. It was held that in case of vesting under Act 2, the vesting will not continue and it will be divested. That is precisely the paragraph 31, and it has been discussed from paragraph 28 to this. And this has been, my lord, upheld. This judgment has been upheld by the special bench. And, my lord, the Supreme Court, what happened, my lord? Prior to this filing of these four judgments were challenged in separate appeals before the Supreme Court. Prior to that, similar type of one matter was there, that is State of West Bengal versus Lokhiranipal. So these four matters were tagged with that. The next four civil appeals relates to the four appeals mentioned in the
Savitri.
Those four judgments, the special judgment. And this has been, this Savitri Devi judgment has been, this appeal has been dismissed by the special bench. This is one set of judgment. Then, my lord, next kindly come to 2013 one. But there are so many judgments I have not cited. Kindly come to this.
Need not. Yes.
2013 one CHN Cal 444. This is kindly come to para 47. Now, my lord, what happened in this case? I am not stating the background. What happened in this case? After the lapsing of all these by virtue of 1997 Act, that in 2011, another act was published called the Land Acquisition and Validation Act 2011, by which certain lapse proceedings were sought to be validated by the act. And that act was challenged and has been decided by the division bench. In that context, your lordships kindly come to para 47.
Yes.
There is no question of validating any lapse proceeding under Section 7A of Act 2 of 1948, and by no imagination the 2011 Act, having its retrospective commencement from 1st April 1997, can be said to have revised and validated an acquisition which has lapsed on or before 31st March 1995 by operation of Section 7A of Act 2 of 1948. In this case, what was the notification was prior to 2 years before 1994 Act.
So therefore it lapsed.
So it has lapsed. There is no question of reviving this. Then, the most important part is what your lordships kindly come to para 51. This is most important. What I am saying regarding vesting. In view of lapsing of the acquisition proceeding under Section 7A of the Act of 1948, the title of the original owner revives. Even if any portion of the land covered by the notification issued after Section 4(1)(a) was transferred subsequently to any third party person, namely in favor of any one of the present applicants petitioners, then also after lapsing of the acquisition proceeding, the title of the original owner would revive. The subsequent purchaser and the original owner will thereafter be entitled to work out their respective rights in respect of the land, and we are not inclined to decide the same at this stage since it is beyond the scope of the appeal. So this is the clear finding of this court, that if the 4(1)(a) notice goes, title of the original owner revives. That means lapsing goes. That means vesting goes. Your lordship was considering the concept of vesting. Once vested, title. But here it has been clearly held that the title goes, title reverts back to the original owner. But this has also been kindly come to the next unreported judgment. Kindly come to second page. This judgment of Mandodari Bhakat, it was challenged in Supreme Court by the Coalfield India and also by the State of West Bengal. Kindly see page 2. And another rider is there that will be necessary. Permission to file additional documents is granted in view of what has been recorded in our previous order dated 14 November 2007 and the report of the district magistrate Paschim Bardhaman submitted pursuant thereto, which would indicate that there is no mining activity on the land in question. We find no good reason to interfere with the order of the division bench of the High Court. So, order of the division bench in Mandodari Bakat was affirmed by the Supreme Court. Not only that, then one rider is there. All the special petition accordingly dismissed. It will, although no reasoning is there, I will not much rely upon this. It will naturally be open for the state or for the acquiring authority to take steps under the provisions of right to fair compensation and transparency in land acquisition and rehabilitation.
That is independently if they take.
No, in this case, left Supreme Court observe. If they want to, my lord, no reasoning has been given. No reasoning, I must admit.
To take steps under the provisions of the, that will be a fresh proceeding.
Yes. So, my lord, what the Supreme Court held, my lord, I must confess, my lord, no reasoning has been given, but the Supreme Court observed that if the proceeding under Act 2 lapse, then if you want to acquire the property, you are to go to 2013.
That will be a fresh proceeding.
That direction your lordship has given here. That direction, that's why I am relying upon, my lord. That direction you there, your lordship has said the fresh compensation is to be determined according to the existing law. Existing law means 2013.
Yes, 2013.
Then, my lord, all the judgments, all these many other judgments are considered by the division bench of this honorable court. Very recently, in, my lord, the case of Pawan Kumar Chaudhary, the judgment was passed on 16th of July 2025. But this is the copy I have given.
Yes.
The relevant paragraphs are kindly come to para 54 of that judgment, unreported judgment. But I am not citing the all Savitri Devi, etc., etc. Mandodari Bhakata, everything has been considered. I just want to point out regarding lapsing of the proceeding, what will happen.
Yes.
Statute noted above, 54, statute noted above, provide for the time period within which collector is required to make and publish an award in scenario specified. Default in making and publishing the award within the time period stipulated causes lapse of the notice under section 4.1. Now, today it is being argued that it is an error with error of jurisdiction. So it is not altogether a void ab initio. So the question is this: always, all along this court has held, if you fail to declare the award within the statutory period, then the notice under section 4.1 lapses. Then, my lord, para 54, I have noted all paragraphs. Then kindly come to para 56, last sentence. I will not trouble your lordships. Para 56, last sentence, my lord.
Yes.
In the event, but the last line of that page, in the event of non-compliance of any such statutory provisions, the notice under section 4.1a of the Act 2 of Act from 1948 stands lapse. Then 62, 63 are relevant. I am skipping it over. Kindly come to para 64. I am trying to be as just as possible.
Yes.
64.
64.
I have given you lordship's note as possible in your notes.
Yes.
After 4 lines, vesting as provided under section 4 of the 1948 Act is subject to acquisition proceeding being completed within the validity period of 1948 Act, and in the event of failure to do so, then within the time stipulated for a valid migration of the proceeding from Act 2 of 1948 to the 1894 Act. So, always it has been consistently held that notice stood lapse by operation of law. Then, the second point.
What is this migration of the proceedings from
migration? My lord used the word migration.
In what sense?
Migration of this word was used because 1948 Act expired on 1997, 31st March 1997. Then, my lord, in order to complete some proceedings, initiated under 48 Act,
Right.
1997 Land Acquisition West Bengal Amendment Act was published.
Yes.
So, Lordship used the word migration, that if you want to complete an incomplete acquisition proceeding initiated under 1948 Act, you have to migrate it to 1997 Act. In that context, possibly, as I understand, my Lord has used the word migration. Migration from 1948 Act expired to 1997 Land Acquisition West Bengal Amendment Act.
Right.
Then, my Lord, the second point regarding that this Shaktipada Chaudhuri, my Lord, your Lordships kindly see that my Lord has said the Shaktipada Chaudhuri, your Lordships kindly see that two pages judgment where this court has held that in Act 2 proceeding, land acquisition award is to be declared under the Land Acquisition Act. Shaktipada Chaudhuri, my learned friend, has declared. Shaktipada Chaudhuri. Your Lordship, kindly find you that is your record. They have found. Yes. Shaktipada Chaudhuri has your Lordship's got.
Yes, yes. Mr. Sengupta gave us.
Has relied upon. So this is, we have heard the second page, we have heard the counsel for the parties, the order of the land single judge cannot be sustained since the acquisition proceeding of the land in question was initiated under Act 2 of 1948, not under Act 1 of Land Acquisition Act 1894. Hence, Section 24 or 26 of the Act cannot annul to the benefit of the writ petitioner. This means that the writ petitioners will not be entitled to the benefit of determination of compensation in terms of the provisions of the 2013 Act. This part of the I say that this decision has been rendered practically without interpreting the scope of 1948 Act or Land Acquisition Act or the 2013 Act. So, in subsequent, I have said, impliedly it has been overruled. That judgment I have given. Kindly come to the next judgment in my bundle. It is the case, yes, one of the honorable judge was same. That Shaktipada Chaudhuri's judgment was passed by my Lord Mr. Justice Orijit Banerjee.
Yes.
Sitting with my Lord Mr. Justice Krishna Rao.
Yes.
Then, my Lord, in later judgment,
yes,
MAT number such and such, that is FMA number 166 of 2018, the Honorable Justice Orijit Banerjee and the Kaushik Chando. My Lord, in this case, what happened, I have given in my written notes. In this case, the property was sought to be acquired on 9.
This judgment was written by the second judge.
Eh?
This judgment was written by Justice Chanda.
But it has been admitted, it has been affirmed by the Honorable Justice. Another judgment I will give to the Lordship. In this case, proceeding under Act 2 was initiated. Ultimately, it was not concluded. The single bench held that you proceedings stood left, so you initiate fresh proceeding under 2013 Act. Matter went in appeal, that is FMA number 166 of C. Kindly come to para 15 of the judgment.
Yes.
In the facts, I do not see any reason to interfere with the order of the impugned, whereby the learned single judge directed to initiate fresh proceeding under Act 2 of 2013 not to pay compensation under the same Act with a further direction to make rent compensation to the petitioner in accordance with law. And this has been upheld by the Honorable Supreme Court.
What is the ratio?
Lord?
This is just a finding. No reason to interfere with the order impugned, whereby direct initiate fresh.
The ratio is para. I have not given the entire judgment. Entire judgment I have given. If your Lordships kindly read para 24. Para 12 and onward. Reason para 12 and onward.
There no proceeding was initiated.
Yes, the possession was taken under section 3(1). Possession was taken. I have to, in that case, I
The
have to,
requisition in order list.
requisition was done, but no 4(1) notice was done.
This is on different context.
No, proceeding was initiated under Act 2 of 1948.
Yes.
Proceeding was initiated, my lord, when
Yes, 48.
proceeding 48 Act.
Right.
My lord, the proceeding starts with taking possession under section 3. Now, if the government wants to acquire it, they are to required to publish a 4. If no notice is published and they continue with the possession, and what happened in this case, they continue with the possession and make permanent construction on the land. Made permanent municipality, made permanent construction, marriage hall like that. Then the matter came up before the court and the single bench held that
Without an acquisition, you cannot do that.
you know,
Without an acquisition, you cannot
you
go on.
cannot do that. So the court held, single bench held that you are to initiate a fresh proceeding under 2013. That has been upheld. That's why I just, so reasoning is there. Not, it is not that the reasonings are not there, why it will not apply. Only I pointed out to your lordships, paragraph 15, to show that this court has held proceeding is to be completed by 2013 Act. Prior paragraph discussion is there.
But this is on a different point. It was required requisition, but no acquisition was held.
No
acquisition, no
but
notice.
ultimately, today question is this, mirror. If any proceeding, either under section 3 or subsequently by publication of another 4(1),
yes,
then the acquisition is sought to be made. So, my lord, if the proceeding lapse,
here this is not a case of lapsing. It did not start at all. It was a non-starter. It was requisition. But
why not
no,
lapse? Why not lapse, my lord?
here, no, the finding of the court in para 12
Yes.
is, Mr. Bera,
Yes.
that, please come to para 12. It is clear that requisition order in terms of section 3(1) of 1948 had been published
Yes.
and possession taken.
Yes.
No notice, however, in the present case under
Yes.
section 4(1) of the Act 48 was issued.
Yes.
And then also it goes on to, the court goes on to hold that in the above facts, section 24 has no manner of application. The
Yes.
provision applies only to a proceeding initiated under the Act of 1894 and no other proceeding.
Yes. But
So no
prior to
proceeding
that,
was
your-
initiated under
Your
1894.
lordship kindly come to para 12 last sentences.
Yes.
No notice under section 93A of 1894 Act as amended by was issued or no award was published. Therefore, there cannot be any doubt that the said proceeding initiated
Right.
never
The
completed.
requisition proceeding never acquired the character of an acquisition proceeding.
Your
But
lordship,
here it's not a question of proceeding was initiated but lapsed.
lapsing
No,
into-
it was never started. Acquisition proceedings were never started.
Your lordship, I am
State held on to that property.
yes, held on to the property. But when it lapsed, doesn't the proceeding didn't lapse?
There is no proceeding at all. Where is the question of lapsing?
Lapsing because of this.
It was held that no notice was issued at all
Yes,
for
but
acquisition.
your lordship make a distinction between taking of possession and 4(1). If your lordship is thinking that if 4(1) notice is not published, so there has been no acquisition.
No question of, yes. No, that is the
No,
findings of their
but
lordship,
that is
not
not
us.
but that is not the position of Lord to my utmost.
But you are citing this, the judges
I-
held that.
I am saying because of this reason, kindly see the situation. What happened to this proceeding after?
But how is this relevant to you? Here the court says it was requisitioned. No acquisitions proceedings started at all under 1894 Act. Therefore, there is no question of applicability of section 24.
Yes.
So if there was no starting commencement of any acquisition proceeding, on that ground there is no question of starting and lapsing. Lapsing can occur only something regarding something which commences.
Lapsing of the
There was no lapse. There was no initiation at all. That is the finding.
Your lordship is acquisition proceeding, but here if the proceedings to lapse on 31st March 1997. Your lordship has a distinction between proceeding under section 3 and 4(1)(a).
Yes.
Your lordship may say the acquisition proceeding lapse, but here I say that the requisition proceeding also stood lapse because of 31st March 1997 Act 2 effaced from the statute. That is there in Savitri Devi's case.
That is not spelled out in so many words.
Not so many
This
words.
is not a precedent for that proposition.
It may be, but position is this. It stood lapse by operation of law on 31st March
But
1997.
this probably is not a German for our present. Yes, what else?
Then, my lord, this judgment was upheld in Supreme Court. And with the rider, my lord, kindly come to paragraph 11. Just a minute, my lord. Paragraph 9 and 10. 9, my lord, the last sentence is in such circumstances, the finding of the division bench of High Court that the impugned notices action is vitiated by Article 300 of the Constitution, or that the respondent
Supreme Court also held there is no denial.
deserve to be compensated under 2000.
That is different, but there is no denial to the fact that the subject land was never acquired in accordance with law.
Yes,
Requisition of the land could not be for an indefinite period.
Yes. So,
Indefinite
in
it
any
could.
case, so the Supreme Court only modified to the sense that an arbitrator should be appointed and a particular date for compensation was given. Then, next judgment I have given, that is the judgment, unreported judgment, MAT 207 of 2018.
Yes.
Along with several other judgments. Here, my lord, my learned friend also appear for the PWD.
Yes.
And my lord, in this case also, this is by Justice Banerjee and Honorable Justice Sinarai.
Yes.
Here in this case also proceeding was initiated under Act 2 of 1948 and ultimately
requisitioned and abandoned. They were returned to the writ petitioners.
Yes. Then, my lord,
no acquisition proceedings were ever initiated. That's different.
Ultimately, but proceeding was initiated under Act 2 of 1948. Proceeding.
Requisition.
Yes, requisition. This court held.
That's beside the point. That's beside the point.
So, my lord,
not the point in consideration before us.
So, my lord, what I say that the proceeding initiated under all the judgments were there. Ultimately, this court held in paragraphs. Of all judgments. Para 15. So, similar direction was given to complete the acquisition proceeding under 2039. So, my lord, in this case also, this is the sum and substance, my lord.
Right.
Now, my lord, last, my lord, I want to submit. Your lordships will kindly pardon me, my lord. I may not be, my lord, to point out one thing. But your lordships kindly come to. Well, your lordships, I have kindly pardon me for citing these judgments. But your lordships, but for my satisfaction, I will cite this judgment. Now, kindly come to take the memorandum of review. The judgment at page 19, page 18 and 19. Page 18, it starts operative portion of the order.
Yes.
Appeal preferred by the state dismissed. 2, cross objection filed by the appellant is allowed. Then an award passed by the ATO is set aside. Then, my lord, the 4. The land acquisition collector North 24 Borgonaj is directed to initiate a fresh proceeding for determination of the compensation of the acquired belonging to the respondent in accordance with the provisions of the existing statute governing the issue, taking into account the market value of the land as on the date of 4-1 and notice 11th of March 1997. But I am, but your lordships has directed to this. I have not come up with review. The government, after all, your lordships has noticed several judgments which I have cited before your lordships. It shows that the notice does not exist. So can an award be declared on the basis of a lapse notice?
But we cannot reopen that now.
That's
if it was an appeal, we could have.
Yes, in the appeal could have.
If it was an appeal, we could have.
I could have filed a review.
Could have filed a one-page review.
But that's why I am submitting your lordship may not interfere. But
we cannot, even if you want.
Yes, can.
If it's a palpable error, then we can.
Can.
We have to say it's a palpable error.
I may be wrong.
No, but that is on very high ground, Mr. Vera.
Lordships kindly consider. I may be wrong, mirror with my.
That's on a very high ground.
Your lordships knows, mirror, possibly knows. This is the judgment AIR 2000.
If the court feels there is a wrong in the order of the court's hands are not bound.
No, not bound. Your lordships kindly carry AIR 2000 Supreme Court 540, para 15 and onwards. I think your lordships can suo moto can.
Yes,
that's why.
That's what you are saying. We can,
that's why I very beginning your I lordship beg to be excused.
Which
para 15 and onwards.
No, court can correct its own errors.
Yes.
But since there is a specific provision of review, that power is
power
very
of
limited.
review is there.
Very high power.
Very high power of your lordship under Article 250.
Article 215 also there are certain judgments we say Chartered High Court has some special powers in a sense. But we have arrogated that to ourselves, I feel.
No, but that's why
Chartered High Court, we are not special as far as judicial side is concerned.
That I beg to be excused for citing.
Apart from intercourt appeal, obviously.
Yes, intercourt appeal. So, Miller, this is.
But now all high courts have adopted our this latest patent and either by way of statute or directly. So intercourt appeal is.
So, Miller, Miller, the basic question is this: that there is no apparent error on the face of the record. If at all the apparent error that I have pointed out, which is required to be corrected, not any other apparent error in there.
Well, only one thing, my lord.
The last judgment which has been cited, my lord, I think that is not.
No, you keep it on.
Well, so far my submission, actually what I have submitted, that was not been dealt with by my senior friend. My lord, never. Basic point, my lord, kindly consider one thing. All those judgments, my lord knows that if that after all rightly, wrongly at division bench, my lord knows that the Privy Council judgment. I have an occasion to
appear before the Privy Council.
No. I have an occasion to read so many judgments of the Privy Council, at best 3 pages maximum, 3-4 pages.
Then we did not have law clerks.
Yes, 3-4 pages, but the substance is there. But my lord, the substance is the ratio, and the ratio is inbuilt in the decision of the Honorable Division Bench.
Yes.
If something has to be set at naught, it has to be decided by the larger bench.
Right.
Number one. Number two, my lord, kindly consider one thing. The judgment, my lord, this Savitri Devi, he has much emphasized on the point. I have a great respect because I didn't see any honorable judges, man like that, like Mr. Bhattacharya.
Which Mr. Bhattacharya?
Bhaskar Bhattacharya. Yes, my lord.
After retirement, he has become Mr.
Yes. Till today, my lord, I had an occasion to, my lord, come across, my lord. I bowed down. Mr.
After this, your review has to be dismissed.
My lord, no, that is not the thing.
Yes.
My lord, kindly consider why I am saying, with due respect to the honorable judge, the then honorable justice.
Yes.
My lord, kindly consider Savitri Devi's last 2 paragraphs. There it is written 9(3)(b) is not applicable, maybe, but 9(3)(a) is applicable. So not that everything goes.
No, everything cannot go.
Yes, that's why my lord made that observation and put the question to my lord senior friend that something is to be there, has to be proceeded with. So Savitri Devi's case is not that blanket fashion 1940 Act goes because of the amendment incorporated in the 1997 in the Act 1 itself. My lord, kindly consider. So for 9(3)(b), the Honorable Larger Bench, presided by Honorable Justice, then Honorable Justice Dr. Bhattacharya, my lord, has taken into account the 7A of that Act 48, but never took into consideration of the statute itself. So if it is not, if nothing, because anything contrary to the statute, it is to be treated as a nullity or a par incuriam. Even judicial pronouncement, division bench. Coordinate bench cannot overrule. Yes, sometimes it can, provided there is an absolutely void ab initio, that judgment. That judgment, Supreme Court judgment is there. My lord, why I am submitting 9(3)(b). My lord,
You say Justice Bhattacharya's three-judgment
three
judgment was
judgment judgment only to the extent
was par incuriam, the division bench will hold that.
No, my lord. What I am submitting, if, my lord, kindly see, if some portion of the judgment is treated to be a par incuriam, then my lord has my lord, kindly consider that three judgment maybe. But my lord, if it is contrary to the statute, why I am making that submission? Because it has got a lot of significance, because not in this case at all. My lord, thousands of crores are being involved so far the state cases are concerned.
Absolutely, yes.
So, my lord, my endeavor would be, my lord, to save the state so far as per my ability. Now, my lord will decide what is the what is best one, or what is, that the decision will come. My lord, only thing, my lord, 9(3)(b), why I am submitting? My lord, just my lord, academic.
No, absolutely, yes.
Academic, my lord, learning, my lord. Because this was not 9(3)(b), my lord, that amendment. Amendment in the Act 1.
1948 Act 2.
Act 1.
1948 ওটাও লাগবে।
Act 1 এর মধ্যেই আছে।
In Act 1, that has been
Act 1 এর মধ্যেই আছে।
Section 9. In Act 1, after in
No, we need a copy of the 48.
Act 1 দেখলেই হবে, 48 দরকার নেই।
48 Act, not
Well, 48 Section 7A, because yes.
Judgment. Act 2 of 1948 লাইব্রেরি থেকে একবার আনিয়ে নিন তাহলে। Act
because I am getting that opportunity to advance my case as per my ability. After all, whatever we decide, my lord will decide, and this has to be a law. No. My lord, kindly consider 9(3)(b). My lord, before first, my lord, kindly come. Sorry. My lord, kindly come to
yes
9(3)(b). My lord, this is a legislative action, legislative act.
Yes.
My lord, legislative act, my lord, the authority or the honorable judges, as was done at lower court, has to
go to other court.
yes, has to follow the law as laid down in the legislative act. My lord, legislative act says, my lord, I could have understood there is, my lord, some lacuna or some, my lord, inconformity. If there is nothing, every wording in the statute has to be complied with. My lord, kindly see 9(3)(b).
Yes.
Last, provided further. My lord, kindly see, this is very important, because most of the cases it will come, my lord.
It is.
Provided further in every such cases, 9(3)(b).
We are reading it. Please continue.
The collector shall make an award under Section 11 in respect of such land only for the purpose of payment of due compensation to the person interested in such land has, comma, upon the collector taking possession thereof already vested absolutely in the government fee for money. So, the legislative intent is clear that vesting cannot be, even if 7A comes into play. Otherwise, this provision would be redundant. Provision provided further would be redundant because the the larger bench takes into consideration of 7A. Then that means virtually you are deciding a case contrary to the act itself. Because I could have understood, then this will be redundant. Already vested. That means it was vesting remains. Well, there is a catch, my lord, because it is my lord thinking, my lord, subject to my lord's approval. But my lord, there is a catch. This point was never urged before any of the court of law. And whatever judgment he has cited, my lord, that was not taken into consideration of these latest judgment. Supreme Court and any other court, my lord, did not take into consideration of the latest special bench judgment, there is constitutional bench judgment, 3 main benches that I have cited. Even section 4.1a initiated, my lord, even if it is initiated, if it is not initiated means my lord is absolutely right. Unless acquisition takes place, there is no question of initiation. Like parameteria, my lord, similar thing. Like section invocation of section 4.1, my lord, I have already shown that initiation for acquisition, not for requisition. And 17.1 is for, my lord, saving and is parameteria to, my lord, section 4.1a. So reading 7a, you cannot, sorry, my lord, I am maybe allowed to make humble submission that the honorable, the larger bench cannot go into that question, go into the consideration of section 7A of that 1948 Act. Instead of relying upon this act itself, that is Amendment Act, that point was never asked before this, any of the honorable high courts or division bench, Supreme Court, any of this side. For the first time, I have raised this point before my lord. And my lord, kindly consider, take the example, so far this client is concerned. My lord, apart from this, my lord, kindly consider one thing. My lord, the approbate and reprobate is a principle that is inbuilt in the doctrine of whoever, doctrine of election. So one way, they are accepting the acquisition compensation that is passed by the district judge, district magistrate, collector, and the enhancement was also they have taken. So they have accepted that. Now they did not raise any point before that reference case. No, it is a void one. They are accepting, and now in court, the cross objection, they are taking a point that is a void after accepting the money enhancement as well as all monies. This is absolutely called will become under the doctrine of.
Since they have put in a very short written notes, you also put in a short written notes. You want to keep it on record.
Yes,
so that we don't miss out.
That should be a law. Yes.
Very short written notes. You have already cited the judgments. Need not give copies of the judgments. Just bullet points. Very short. Whatever you have argued. Yes. Thank you. Hearing hearing of the review application is concluded.
Obliged.
Judgment is reserved. Hearing in the review application is concluded. Full stop. For the purpose of written notes of arguments filed by the respondents in the review application be kept on record. The review applicant shall file the written notes of arguments on September 2, 2023.
Just bullet points.
Pardon?
Just bullet points.
Yes. September 2, 2025, when the matter shall be listed under the heading to be mentioned for such purpose.
Instead of September 2, 5. If my lord,
September 5 is a holiday.
5, then my lord, after that. Because my lord, because I have to.
September 8th, September?
Yes.
September 8th, 2025?
Yes. Obligement.
দুজনের বইটা এখানে চলে এসছে একটা বই।
And I am for the writ petition respondent. All the points have been covered up by the Mr. Shishano Bandyopadhyay.
Yes.
I'm just giving 2-3 points. I will not take more time.
Yes.
So let's kindly come to their writ petition first. The allegation was that, I'm just coming to that, but the allegation was that signature has been obtained in the blank papers. This was the wild allegation. To that effect, Mr. Bandyopadhyay has referred the representation dated, just a second, my lord, page 60, the representation 21st June 2024. There is no such pleadings or no such. And now you'll also kindly come to the page 62. That is there is a reference that our signature has been obtained in the blank paper.
Right.
Now you'll also kindly come to that petition, that representation dated of 20th August 2024. Now you'll also kindly come to the writ petition itself. It has been affirmed on 5th February 2025, page 45. Page 45, writ petition affirmed on 5th February 2025.
Yes.
Now you'll also kindly come to the page 23, that is the pleadings there. Paragraph 7. May I read, my lord, once, or you'll also be looking?
Yes.
The SCF has inquired into the petitioner's application on 29th May 2020 through the area inspector and supplies when the area inspector took measurement of the petitioner's shop and office room and verified the documents with original obtained signature of the petitioner on some papers without giving any opportunity to go through the same. It is not that in the blank paper. Now, Lordship, kindly come to the signature part 1. That has been annexed with the affidavit in opposition. Yes, ma'am. Page 38, sorry, ma'am, of the opposition, part 2. He has signed.
Yes.
It is not that he has signed in Bengali, has not been explained in the vernacular. He has signed in English.
Yes.
Without verifying, there is no question of verification. It is a map, sketch map. Yes. And what is said that the SCF has inquired into petitioner's application on 29th May 2024 through the area inspector food and supply Shantipur when the area inspector took measurements of the petitioner's shop and office and verified the document with original and obtained the signature on some papers without giving any opportunity to the petitioner go through the same. Not that on the blank paper he has signed. Now,
this is the only place where she signs.
According to them, this is the only page he has signed.
There is no other document which is signed.
No, I could not, at least I have not found it. And so far, the other issues, my lord, that whether an ineligible candidate can challenge the eligibility of, can challenge the selection, that has been argued. I am adopting the same.
Obviously.
So far, the judgment which has been referred by my learned senior friend, that has been distinguished, and so far the judgment who I ought to serve, that ought to place before you, that has also been placed before your lordship. And another thing is that, well, essential and non-essential condition of the my client is concerned, that is the conversion. That is their argument against me. That is the only. Let us kindly come to the page 47 once. So far, my page 47 once.
Of what?
Of the writ of the stay application. This is the. You also will find the heading. It's eligibility criteria.
Yes.
Part 2. Now you also can come straightway to C, bold C, capital C.
Capital C.
However, if any of the wall or floor or ceiling / roof is incomplete on the day of inspection, the go down will be treated as incomplete and the application will not be further processed. It will be marked as incomplete go down in portal and size of picture as on the day of inspection. My lord, that's why I'm reading this. Complete go down in the portal, size and picture as on day of will be uploaded. It is not that only taken the signature. The signature has been also been uploaded. It's an incomplete go down. However, no marks will be allowed against such application. He will be treated ineligible. Thereby, my learned senior friend's client has been declared as ineligible. He cannot challenge the eligibility. And now another thing is that so far the conversion that already your lordship has held, this is not an essential condition. Why I'm saying, once again I'm saying, only this part of the vacancy notice says that if you not fulfill this, you will be treated as ineligible. No other place it has been said, but non-submitting this, you will be treated as ineligible. That's why it is the essential condition. Since my learned senior friend's client has not completed has not fulfilled the essential condition, he is an eligible candidate. And so far, other manner, I don't want to place anything else. That has already been covered. Everything has been covered by Mr. Bandyopadhyay. And so far, the judgment your lordship has already.
Yes.
I am not relying even on judgment also.
Yes, Mr. Sharma.
My lord, let me first give a little brief. The submission of state is actually clubbing two issues which are separate. But with passage of time, the courts have evolved law relating to tenders. Say, in an open and shut case, a tender declared, an unsuccessful candidate comes, court says no, will not consider you. Or he cannot challenge, cannot challenge the tender results. The unsuccessful candidate cannot challenge the tender conditions. The unsuccessful candidate cannot ask the court to evaluate the selection process, re-evaluate the selection process and sit in appeal and say that I could have got some more marks. Cannot. And scope of natural justice in a tender case is also restricted. Now, all this, there are other restrictions also. May I say these as a tender jurisprudence? But our old trusted administrative law still retain its position. Now, the selection process has to follow administrative law or fairness in action. After selection process is over, the tender jurisprudence takes over. There are two rooms, two compartments.
Yes.
One has to cross the first room to enter the second room. Now, these two rooms cannot be merged. So, the cases I found cited, my lord, the principles are not disputed, but those principles doesn't apply to me. Because instead of dealing 15 cases, I'll treat them in a group. I'll try to answer them in a group. Now, so I did not come to court after tender process is over. Rather, I came to court while the selection process was going on, alleging bias in selection process, namely to sign on blank paper or without showing me some papers. And also there are some, the inquiry report shows some blatant biasness. I'll come to very, so court directed principal secretary to consider. To consider what? The selection process, obviously. Now, pending consideration what did he say? This principal secretary found a second inquiry is necessary, whatever reasons. Now, good, bad, that order nobody has challenged. So, and directed a second inquiry. Second inquiry found deficiency in both private respondent as well as the appellant. Now, till then, my lord, the results are not declared. So, we are still in administrative law field, room. We are not crossed the chokat. So, following principles of administrative law, my lord, the second report should have been given to both the parties. Their suggestion and their objections are to be invited, and they should be given a hearing. My case is nothing was done. The second report was not furnished, and the party is not allowed to make submissions or explain their deficiencies. So this non-furnishing of the second inquiry report and not allowing to make submissions, my lord, that comes within administrative law field, and tender jurisprudence is not applicable. An opportunity of hearing should have been given, first supplying the report, adverse report. Lordship, the second report, Lordship will consider a thing like, say, Order 26 or Order 39, Rule 7 case. The court directs a commissioner to make an inquiry, file a report. Can court, without further hearing, pass a decree on the basis of report without giving the report to the parties?
It's not a civil suit we are talking about.
Of course not.
The
Of
analogy
course
is
not.
inappropriate.
Of course not, but by that time, the results were not declared. So, the principles of natural justice, and he was hearing pursuant to order of court, and I'll show that order. He says that I'll pass a final order after that. So even before a decision was given, a statement has been made that there was no stay. So we were free to appoint. My lord, then what for the hearing was going on? I was asking myself, my lord, what purpose that hearing will serve?
They say the offer was given, but the license was not yet issued.
My lord, it means the same thing. I mean, this is just jugglery of words. This is jugglery of words, and so even before passing of the order, and his first order says that it will pass. I'll show that portion, last portion of the order.
Yes.
So I have challenged the decision-making process and not the process. It's not my case. I was entitled to some 2 more marks here and there. Not that, and openly blunt biasness. Let me show 1 or 2 examples. First, Lordship sees the first order by the principal secretary. I not
a rehearing. Not a rehearing.
I know what I'll
just repeat on whatever point they argued. Cannot reopen the arguments.
Lordship, can you?
We cannot reopen the arguments, Mr.
Well, I am not reopening. I'm sorry, Malad, but one thing I might have.
Yes.
Logically, last sentence says, page 74, last sentence, I'm just reading out.
Yes. Yes.
After receiving the said report from the inquiry officer.
74 of what?
74 of the state
main petition. Oh, yes. After receiving
the report from the inquiring officer, the final order will be passed upon considering the inquiry report.
Yes.
So, the final order, until the final order is passed, my lord, no selection process could have been started. It's parallelly. And regarding biasness, Lordship, apart from the blank papers, logically sees the inquiry report of the respondent number 6, which starts at 41. One or two things I'll show. And one more thing, well, in that 1300 MAT, Lordship decided that the court need not go into, if they disclose some lease deed or the conveyance, the court cannot say whether it was Danga, Bashbangan, Jol, or whatever may be. Lordship, can you have a look at page, the inquiry report at page? At page 47,
as per the eligibility criteria, the vacancy notification, Mr. Sarkar, they are to rely on, the authorities are to rely on whatever document for ownership, any document which they file regarding that ownership, the description of the document, they will go by that. But not, they cannot assess the records of rights for ascertaining the character in the records of rights. That is what we heard.
Lordship.
So they can go into the question, but only on the basis of the document produced by them. Whatever is described there.
Not issued. First page. Give me. 69.
Is B reads A, small b reads document showing character of land as Dukan commercial vastu. So the document will be relied on for whatever it's worth.
In this case, এখানে বলছে ও not given, deed of conveyance not given, সেটা কোথায়?
Page 48.
কোথায়? Lordship, can take page 48.
You are at page 48. Actually.
Page 48. This is F.
Yes.
Whether the conveyance, purchase deed, purchase up to the Property Act received and NOC of other owners have been verified with the original signatures called. All documents are checked and verified with original.
No, this
And
is page F.
F. Whether conveyance, purchase deed.
If there is no F in page 48.
At page 71, F.
After 71, your
One
lordship will find F. There might
Page
be
48, item 71, sub clause F. In the AO, in the F in the opposition. I'm so sorry.
Yes, F is whether conveyance.
So conveyance, it's yes, no, not produced by the applicant, and all documents are checked and verified with original.
Yes.
And then, so whether the conveyance was even given, we are not very sure.
You cannot fish out at this stage.
Yes. Okay.
Presumption is it was given, official act.
mark
Very
yes.
good.
It is marked
And
yes.
and now my inquiry report, logically see, at page 34, my report.
Opposition.
Opposition, Malik. Item 56.
Yes.
Whether construction of shop, office, godown or pakka, brick or mortar wall. Yes. If the wall is yes, and then Lordship turns over the page 35 top, status of roof. Tick is made of concrete slab, yes. My lord, and 58 says one or more walls are not complete up to the roof level. Well, unless the walls are up to roof level, how the roof can be cast?
No, one side, the photograph is was annexed there also.
Yes, one photograph.
Look into the photograph, there's a gap on one side.
Photographs also. Without the wall, the slab stands
No
on.
theory. Actual photograph has been given. So we looked into the photographs also.
Actually, our copy is very black and white.
Our copy is
after
also black
Xerox.
and white. But there's a space, that much we can see.
Space. Lordship is.
We cannot go
Look into this.
In reply,
Look into
Mr.
this.
Shorter, please be just short and
Very well.
whatever they have asked. No, don't re-argue them at.
Very well.
Yes.
For the deposit discrepancy, it was condoned. Prior to that, unless it is condoned, they could not have issued the offer.
সেটা বলেছি and regarding prejudice, a thing has been said about prejudice.
Yes.
Well, with utmost respect, that prejudice theory has been diluted subsequently because 2015 the point was that it will not cause any prejudice. Who can say? Subsequently, that was a Karunakaran ECIL was a earlier decision. Subsequently, it came up for consideration that who can say that there will be no prejudice. It is said that the authority who is passing the order cannot argue or cannot say that if I don't supply, he will not suffer any prejudice. It is for a court to consider if the report was given, he was allowed to explain whether there could be prejudice or not. One decision.
Obviously, the court has to decide. Even if they rely on the
authority, authority cannot decide. All I say that, and moreover,
no, they're not deciding. They're arguing. It did not prejudice. We'll have to decide.
And otherwise also, the nothing will happen. That is not correct. The larger bench decision. It was the first two bench decision. Refer to larger bench. In larger bench, the stringent law in the second two judges decision was diluted, and those are quoted subsequent approval in other judgments. 2015 at SCC 519. Lordship,
we won't take any further judgment.
Okay, very well, very well. All I say, my lord, this is
you can put in your written notes of arguments. You put this point.
Very well, my lord. Then.
But no new judgment. Don't put in any new judgment there. How soon can you file a written notes, Mr. Sharkar?
Lordship, give 3-4 days.
3-4, obviously. And you, Mr. Bhattacharya and Mr. Bandyopadhyay, anybody is there from the state? How long?
3 to 4 days.
So we are today on 28th. We'll put it on 3rd of September. Next Wednesday.
Little more time, 1 or 2 days.
That is 6 days.
I think
4-5 days.
I think that's enough.
3rd September.
3rd September.
I will just bullet point. I will.
Bullet point. Everybody bullet point. Shortcut will also.
And the books, paper, books, Xerox copy of the book.
Already given.
Yes, your certificate, your judgments, you have citations, you have given photocopies. Need not give again. Whatever you handed over, did not give. Hearing is oral arguments are concluded in the matter. Full stop. The matter shall be listed on September 3, 2025, under the heading to be mentioned for the purpose of filing of written notes of arguments by the parties.
Okay.
3 written notes. Thank you very much.
No need to exchange notes. We'll
You
just
can. Why not? You can exchange soft copies.
After filing, I'm going
Please just check that no additional citation is given, because it may get mixed up. You have today other judgments, so please take care that they don't go into the.
But
by mistake, it sometimes happens by mistake, entirely by mistake, not deliberate. Today I have brought certain judgments. I did not permit you. Sometimes what happens is those may get mixed up and get into that.
There is a judgment which is not cited in court, mentioned in written notes and argument. cannot
Yes,
be considered.
you take care that that does not happen. You cannot take care. She'll take care. Yes.
We are, well, we are deeply obliged, my lord, for
Thank
the
you very
patient
much,
hearing
Mr.
here.
Thank you. Call.
Lordship, I don't know, 14 and 15, I'm paying for not this week.
We're just granting notary, not passing any order, or what? Should he pass an order? On the prayer of the appellant, we are on the prayer of the petitioner, the matter is adjourned for the day.
Good, Lordship.
Name. Only your name.
Okay, sir.
Not to the brother. Order the good. Then, right. সারাদিনটা থাকুক এই ভয়টাই পাচ্ছি, খুব সাবধান। আস্তে আস্তে, কোনো চাপ নেই। বেকায় পা পড়বে, বেকায়দায় পা পড়বে। Opposition আছে, opposition reply.
Affidavit in reply.
Yes, all should be, yes, all are here.
No, Milord, on the last occasion, we have filed opposition. Now they are filing a report.
Oh, yes. Good. Thank you, Mr. Bondal. Yes, please.
My case, my lord, before your lordship,
Yes.
pertain to rejection of mutation.
Pertain to
rejection of mutation.
So that was challenged before the tribunal and
What happened, my lord? The petitioner before your lordship purchased the land. It is a water body in the year 1999.
Yes.
Thereafter, my lord, the Sebayit of the deity filed a suit in the year 2003 for declaration on permanent injunction against the petitioner before your lordship.
Yes.
That suit was dismissed in the year 2011. No
Dismissed on merits.
Merit. No appeal was preferred against the said judgment and degree before the Honorable High Court.
Yes.
Thereafter, my lord, in the year 2014, a representation was made before the authority for mutation the particular property.
You made the represent.
Not my lord. It is the on behalf of the Director of Fisheries. It is a water body, my lord.
Oh, yes.
Rearing fish by the
Whatever, right.
fishermen, my lord. That was not considered.
Who are you? You are, you are a fisherman.
I'm the cooperative
Obviously,
subsequent purchaser. Thereafter, my lord, in the year
You purchased from whom? The original owner?
Purchased from the deity through power of attorney holder, power of attorney executed by the Sebayit. It is a registered power of attorney, and that deed was executed on the basis power of attorney holder executed the deed on behalf of the deity.
And after dismissal of the suit, that your title attained finally.
Right.
Right.
My lord,
So,
thereafter what happened?
2014 representation by Director of Fisheries for mutation.
That was not considered by the PLRO. Thereafter, my client made a mutation application with a format. Subsequently, mutation procedure has been changed by way of subsequent notification issued by the Principal Secretary, Department of Land Reforms. And that application with format received by the BLRO. And BLRO did not consider that on the basis of the subsequent notification issued by the principal secretary. There is a 1, 2, 3, and 4 you have to comply with regarding the mutation.
You filed in terms of the changed
Format.
Format. So your application was
not considered. No order was passed.
Initial mutation, only one mutation application filed by you.
Oh, one application filed before.
No, that was representation. Oh, one filed before. That was not in format, but then you filed a proper
format.
Yes.
BLRO did not pass any order. Against that inaction, we filed an application under Section 10, Red with 6 of the West Bengal Land Reforms and Tenancy Tribunal Act before the tribunal.
What was the date of the this application for mutation?
That they have preferred 3 applications. Passed by the fishery director. My lord, your lordship, kindly turn to page 170.
I have already submitted before the lordship.
Yes, that was told by representation by
page 117 of the writ petition, my lord.
Let him complete, Mr. Bandhavadar.
Yes.
So that non-consideration for inaction you came up before the tribunal.
Tribunal.
What happened? Tribunal decided on merits.
Tribunal, my lord, during the pendency of the original application before the learned tribunal, tribunal direct the BLRO to submit a report. BLRO submitted report stating inter alia, first, this case relating to pending the Supreme Court regarding Paschim Bongo Bhumijibi Sangho, and the Sebait are the members of the Bhumijibi Sangho. First. Second point is, my lord, several interim order was passed, and third party right cannot be created as per the order of the Honorable Supreme Court in the Paschim Bongo Bhumijibi Sangho's case. That is why mutation cannot be done, and mutation is rejected without initiating any case, without giving any notice. We took exception against that report before the learned tribunal, my lord.
So third party interest, so by virtue of that injunction, they say mutation cannot be granted. But your purchase was before that.
Before that, my lord, we took exception.
Right.
We took exception in a manner. What happened, my lord, it is very interesting. In the year 1892, this property belongs to my lord Paikpara Raja. I am citing one decision of the Supreme Court before your lordship that is very relevant in this case, and entire facts from 1892 to 1999. It is clear from this judgment. That's why I am praying before lordship, let the judgment be placed before lordship.
Yes, absolutely.
That is not the case of the petitioners, my lord.
Let me finish first, then my learned friend.
No, let
That
him
is not
argue.
in the
He has a right to argue, Mr. Bandhavadar. Let us see.
It is
We will argue when your turn comes.
Yes.
So, Mr. Thakur, you want to say that you want to give the narrative of the development of the law in general?
My lord, what happened? Very, very strange, my lord. Already that has been decided by the Supreme Court. Supreme Court has decided regarding religious endowment created by the owners, Sevites, that is an exempted category under 6(1) subsection Roman 1 of the West Bengal Estate Acquisition Act. For religious endowment, there is no ceiling. An entire proceeding is set aside by the Supreme Court.
But then 14T came in.
I am coming.
5 to 9.
I am coming, my lord.
14M, 5 and 6.
I am coming. I am coming one by one, my lord.
Yes.
Religious endowment created by the trust. It is an absolute devotor.
That has now changed.
My lord, that I am coming. Then my lordship decide, no doubt about it, my lord. Writ petition was moved against the order of the settlement officer. Settlement officer order passed in the year 1967.
Yes.
treating the land is a vested. Deity is a right.
In your case,
That land was purchased. I purchased the land. Thereafter, my lord, appeal preferred. Division bench of the Honorable High Court allow the appeal by setting as the order of the Honorable Single Judge. Thereafter, state preferred an appeal before the Honorable Supreme Court in the year 1982. And that appeal delivered judgment in the year 1999 by affirming the judgment of the Honorable Division Bench. As per the section 6(1), it is an absolute devotor. You cannot take the land treated as vested. Before that, the arbitrator was appointed and suit was filed before the Fort William. An arbitrator awarded that land cannot be impartible amongst the Sevites. And Supreme Court stated heavily relied upon that and said the deity is an exempted category. Thereafter, my lord, after the delivery of judgment, we purchased the land. Thereafter, Paschim Banga Bhumijibi Sangha's decision was rendered by the Honorable Division Bench in the year 1996. Thereafter, against that judgment, state preferred special petition before the Honorable Supreme Court. And several interim order was passed. Till today, that matter was pending before the Honorable Supreme Court. State has taken a plea that subsequent amendment of the West Bengal Estate Acquisition Act under section 14M, state has the power to determine the ceiling, and deity will be treated as a right, although they have stated in their affidavit in
it's a private.
It is absolutely public devotor.
Yours is public.
Public devotor.
Public is exempted. Public
Exempted.
comes under 6.
They-
M6.
Right. They have stated in their affidavit in opposition before the tribunal and before the Honorable High Court that it is a public devotor.
They had held an inquiry.
Everything, my lord, I have placing the.
So they are admitting that it's public.
Public.
They don't have an exemption under the statute. Then DT becomes
14M, my lord, 14M.
Yes.
It is a, my lord, I am placing.
14M 7.
I am coming, my lord. I am
14M
placing.
7 says that.
14M, there is also a exemption.
Yes,
14M
M7.
5. If it is public,
Yes, 5.
in that event, the 7 hectares, standard 7 hectares,
yes,
cannot be treated. That clause has been incorporated by the legislature.
Yes, yes.
But they have treated, state government stated in their affidavit that we have the power under section 14M6. There is a serious contradiction.
No, there's no contradiction. 56.
My lord, better I am placing the Supreme Court judgment, then I am come, my lord. Land Reforms Act.
No, let us see the law first.
My lord.
14T6, your lordship, kindly see.
Yes, 6 is very clear.
6 is clear, my lord. One
Then
matter
lordship
was
kindly
heard
come
by
to
your
case.
lordship, my lord, Mr.
My lord.
J. argued before your lordship.
No, let us yes.
My lordship kindly come to 14M5.
Yes, 5 is regarding a non-public.
I am coming, my lord.
Other than that of a public nature, where is the contradiction?
14M.
One is complementary to the other.
14M5. That lands owned by a trust or endowment other than that of a public nature.
Yes.
Stop, my lord. Shall be deemed to be lands owned by the author of the trust or endowment, and such author shall be deemed to be right under this act to the extent of the share in the said lands, and the share of such author in the said shall be taken into account for calculating the area of the land owned or retainable by the author of trust, endowment, or
Where is the contradiction?
My lord, thereafter, lordship kindly come to clause 6.
Yes, 6 is public. If it's public, then DT will be the right.
If it is a public in nature,
yes,
it is a public devotor, then sealing does not come under the play. under the consideration.
Why do you say that?
The lands owned by a trust or endowment other than of a public nature, then my lord sealing come into play. If it is in public devottor, then sealing does not come.
No. There is no such law. 5 says the lands owned by a trust or endowment other than that of a public nature shall be deemed to be the lands owned by the author of the trust.
My
So
lord.
therefore, they pierce the veil, and it is said that if it's a public religious endowment, the Shebites, the family or the Shebite themselves enjoy it. So it's a legal fiction. Therefore, in case of private author, it will be counted as the land will be counted as the land of the author.
Even then,
but in case of 6, if it's a public nature, then that trust or institution will be deemed to be a riot.
They have treated.
Which is correct.
My submission is,
yes,
as per the judgment of the Honorable Supreme Court,
yes,
in arising of the proceeding under State Acquisition Act, it is clearly held the deity determination of the settlement officer is set aside.
No, but how do you deal with this? If you have to, if you please come to 14.
They have taken the plea. We have not, my lord.
No. How do you reconcile that? You have to take into consideration.
It is subsequently.
Please come to section 14T.
Determination.
Not only determination.
Regarding vesting.
Please come to 8. 14T8. And 14T9.
They have taken plea. My contention is different. My contention is as and when the Supreme Court delivered in the same land regarding the exemption, they cannot take the plea, take the defense of the Land Reforms Act because of the fact.
Cannot take advantage of a judgment if there is a change in law.
I am coming, my lord. State Acquisition Act has not been repealed, even not implied repeal.
Oh, please read 14T8 for us. Please help us in reading 14T8. Please read it out. Please read out first.
Duty of right to furnish return.
No, then it is not that. We are saying 14T. 14T subsection 8.
Subsection 8. Not any withstanding anything contained in this act or in the West Bengal State Acquisition Act 1953 or in any other law for the time being in force or any agreement, custom, usage or degree judgment, decision, award of this.
We are not understanding what you are reading. Notwithstanding anything contained in this act or State Acquisition Act or any other law, judgment, agreement, decree, etc. The provisions of subsections 5, 6 and 7 shall operate with retrospective effect from 5th day of May 1953. And subsection 9 is more specific. Subsections 5, 6, 7 and 8 of this section shall be deemed to have always been inserted in the Estate Acquisition Act. Any officer specifically empowered in this behalf under the provision of the Estate Acquisition Act may, in exercise of the powers, reopen and decide no res judicata. So therefore, with the enactment of this, it is deemed to have retrospective effect from the commencement of the Estate Acquisition Act and deemed to have been always there. So even if there was a judgment of the Supreme Court, Section 8 exempts that, irrespective of any judgment of any court. This will be deemed to be there all along in the Estate Acquisition Act. So by virtue of subsequent enactment, it has been retrospectively put into the Estate Acquisition Act. Therefore, if there was a judgment of the Supreme Court on this unamended provision, that becomes fruitless, academic.
Well, I am citing one decision subject to your lordship approval.
Yes.
There is a point regarding the Estate Acquisition Act, whether Land Reforms Act can override the Estate Acquisition Act. Supreme Court says the Estate Acquisition Act has not been repealed, even not implied repeal.
No. Particular sections, only particular provisions.
Thereafter, my lord,
this has interdicted into the zone of Estate
Land
Acquisition
Reforms Act. My lord.
Land Reforms has interdicted into the zone of Estate Acquisition Act to a limited extent.
My lord, I am coming, my lord. Well, I am citing one decision.
Yes.
2009, Volume 4 SCC. 2009, Volume 4 SCC 453, my lord.
Yes.
Paragraph 14 and 16. The High Court was of the view, my lord. I am reading, my lord.
Yes, yes, absolutely.
Paragraph 14. High Court was of the view that proviso to section 6, subsection 3 does not give a right to the state government to revise any order passed under main part of section 3 in view of 1955 Act. In other words, the High Court was of the view that if the lands are allowed to be retained by an order of the state government under section 6, subsection 3 of the 1953 Act, and was below ceiling limit, then in view of section 14J of the 1950 Act, the power under proviso to section 6, subsection 3 of 1953 Act cannot be exercised by the state government. We regret we cannot agree with this view. In our opinion, the power under proviso of to section 6, subsection 3 of the 1953 Act continues with the state government even after the enactment of 1955 Act or section 14J thereof. There is nothing in the 1955 Act or in section 14J thereof which state that on his enactment, the power of the state government under the proviso to section 3 of 1955 Act will cease to exist. Section 59 of the 1955 Act repealed certain
Yes.
Section 59 of 1955 Act repealed certain earlier acts and regulation in Bengal. Also, it may be mentioned that Section 63 of the 1955 Act repealed certain provision of the West Bengal Non-Agriculture Tenancy Act 1949, which were repugnant to the provision of West Bengal Land Reforms Act, Amendment Act 1981. In any district or any area of Calcutta, Section 30 of 1955 Act repealed the West Bengal Landholding Revenue Act 1979 with effect from the date of notified by the state government in the official gazette's, that the 1955 Act specifically mentioned which earlier acts it intends to repeal. There is no provision in the paragraph 16, my lord. There is no provision in the 1955 Act which repealed the provision of section 6, subsection 3 of the 1953 Act. Nor in our opinion can such a repeal be implied. Hence, we cannot agree with the view taken by the High Court that the proviso to section 6, subsection 3 of the 1953 Act is repealed by necessary implication after the promulgation of 1955 Act, and in particular section 14J thereof. However, we also have to understand the true purport of the proviso to section 6, subsection 3 of the 1953 Act. In our opinion, the correct interpretation of the said proviso is that once an order is passed by the state government under section 6, subsection 3 of the 1953 Act, thereafter the power under the proviso to misrepresentation was made to the state government for obtaining the order mistake made by the state government under section 6, subsection 3 of the 1953 Act, or clause 2, there was a genuine and important mistake made by the state government in passing the order under section 6, subsection 3 of 1953 Act. However, in our opinion, the power under the proviso to section subsection 3 cannot be exercised on the ground that after the order of the state government was part under the main part of section 3 1953 Act, some subsequent developments have taken place. To explain this, we may clarify that there may be cases when an order under main part of section 3 of the 1953 Act was obtained by the intermediary or lessee by misrepresentation or fraud. Example, by stating he has a tea garden, mill or factory or works, although he has none, or that the land he requires for the above purpose is more than what he actually required. There may also be cases where the state government has in exercise in power made by the honest mistake. In your opinion, In such a cases, the power under the proviso to section 6 subsection 3 of the 1955 Act can be validly exercised by the state government. However, the power under proviso section 6(3) cannot be validly exercised on the ground that subsequent developments have taken place after the order under the main part of section 3 1953 was passed by the state government. It was contended by the learned counsel for the appellant in some of the cases that although when the order under main part of section 6 subsection 3 of the 1953 Act was passed by the state government, there was a factory on the land in dispute. Subsequently, when an inquiry was made, 1991, it was found there was no factory at all. Hence, it was submitted, the state government validly passed the order, resuming the state land under section 9. With the opinion, if the submission of the state government is accepted, it will create chaos because the right which was settled 20 or 30 years ago, or even more, may suddenly be disturbed. For example, under section 6, subsection 1A of the 1953 Act, the intermediary can retain the land comprised such and such.
How is this judgment relevant here?
Judgment is relevant, my lord. 1953 Act,
yes,
Estate Acquisition Act has not been repealed, even not implied repealed. The judgment
this is in a
delivered by
specific context. The
judgment,
power under the proviso to section 6(3),
my lord,
whether that
My lord.
was revealed by the Land Reforms Act, it has
Right.
not been revealed.
Here, my lord,
Here we are not speaking about section 6(3) power at all. It's a different
here,
question
my lord,
altogether.
my humble submission before lordship, the land vested under
Mr.
the Estate
Thakur,
Acquisition
there are
Act.
two things. One is that the Land Reforms Act 1955 under section 63 clearly repeals only Non-Agricultural Tenancy Act and nothing else. And there's a saving clause. But in the other sections of that 1955 Act, Land Reforms Act, certain sections have been introduced retrospectively into the Estate Acquisition Act. This case, this judgment was considering only the limited context of section 6 within bracket 3 proviso of the Estate Acquisition Act. It has been held by the Supreme Court absolutely rightly that since 63 that does not repeal the act, nor is there anything in the Land Reforms Act to modify that, therefore 63 remains. All the other sections remain, provisions remain, apart from those which have been modified by 14T, 8 and 9. 5 to 9 actually. So we are speaking about a scenario under 14T 5 to 9 and 14M 5 and 6.
My lord.
So Mr. Thakur, how is this judgment relevant at all?
Relevant, my lord.
This was in respect of section 6(3). We know that it has not been repealed. Nobody disputes that.
Already determination. Can the state government be reopened that? Lordship,
Can the
kindly
state
please the
government?
judgment, first judgment, my lord. I am saying for my satisfaction.
Right.
My lord. Volume 10 SCC, page 376. 2000, volume 10 SCC, page 376. Only question which arises, it's a not very big judgment, but it is required to react, my lord. The only question which arises in this appeal is that land which was dedicated to the deity before the West Bengal Estate Acquisition Act 1953 for the said act was enacted would fall within the purview of section 1 subsection I of the said act.
So this gives your answer, Mr.
Right.
Thakur. This is the question formulated.
Right.
Whether land which was vested to deity before coming into force of Estate Acquisition Act, that would fall within the category under this. So this is prehistoric. We are speaking of historic things. History is, Estate Acquisition Act is history.
Right.
And this is prehistoric. Before coming into force of Estate Acquisition Act, if there was a vesting in a duty, whether that would be covered. It was held in the positive, affirmative.
Affirmative.
We are speaking about vesting during the pendency of subsistence of the Estate Acquisition Act and the subsequent effect of 14T of the Land Reforms Act in there.
Only
That is a
question,
different question.
decided by the Supreme Court, the land which was dedicated to the deity, it is absolute renunciation. It is absolute.
No, that was not the question.
A
The
question is
question,
there in this
question is
judgment, my lord.
formulated in the first paragraph. Only question which arises in this appeal is that land which was dedicated to the deity before the Estate Acquisition Act 1953 was enacted would fall within the purview of Section 6 of the said Act. So this is a pre-1953 Act Estate
Before
Acquisition Act.
enactment.
Yes,
Before
because that would come under the Estate Acquisition Act. We are speaking about the second stage.
My lord, proceeding was initiated by the Estate Acquisition Act.
Yes.
And that was set aside by the Honorable Division Bench.
Maybe.
And that was restored by the Department of Land Reforms. Record was corrected. Thereafter, they want to initiate subsequent proceedings because of the fact.
Mr.
they
Thakur,
put in
judgment is a proposition for only the facts in the context of which it
My
has
lord.
been rendered.
My lord.
That's settled, you know it very well, all of us know it. So this is on the facts of this case, and the judgment is a proposition also on the specific question formulated. This is the question which fell for consideration.
Thereafter, my lord.
Nothing else. The effect of 14T6, 14T9, these were not considered in this judgment,
lord.
Mr. Thakur.
My lord, they could have placed the matter before the Supreme Court when this appeal was pending.
What could have been placed cannot, that is specifically barred from being treated as a precedent. And there has been umpteen judgments, Mr. Thakur, you know, that which specifically say that a judgment, what could have been argued or what could be derived from a proposition of law laid down, cannot be treated to be a proposition in a precedent in a subsequent case.
My lord, that is a res judicata.
No, precedent. The law of precedent says that what could be derived from a precedent.
They have taken, they
A
have
second degree precedent, there is no second degree precedent. What could be derived from that precedent?
My lord,
No.
they have stated that in the year 1999 that judgment was delivered, which I have handed over now, my lord.
Yes.
But special leave petition filed in the year 1997.
Maybe, but these
Regarding
provisions were not considered in this judgment.
Poshim Bingo Bhumijibi Sangho. My second point, my lord, Poshim Bingo Bhumijibi Sangho.
How does it
The
help?
deity was not a party in the proceedings. Only
Sure.
Sebaita the party.
Yes.
Not deity as the party. My vendor is deity, my lord.
Mr. Thakur, you are absolutely justified in saying that this could not be a ground. Pendency of this.
Sure.
But no, but the interim order,
Taking
how
one
do you
decision,
deal with?
my lord?
Yes.
So far Supreme Court is concerned.
Your
Your
party
lordship,
rights cannot be created that injunction.
right? Your lordship knows that mutation does not create any title.
That is a very good argument. That is, at the inception, we thought that.
I am citing.
That's why we asked you.
Right.
Your title was devolved before that.
Beside that. That
Do you have a copy of the Supreme Court judgment? Exact what is there?
My
We
lord.
want to see Paschim Bango that interim order.
My lord, they have
First
stated,
that.
they have stated their evidence in opposition.
We have stated briefly.
আমি বলবো মিস্টার ব্যানার্জি, মিস্টার বন্দ্যোপাধ্যায়।
Very thorough. All of you are, in fact, you are specialists in this branch.
They have stated, my lord, incorporated the interim order in their affidavit in opposition.
Right. Which page, Mr. Bandhavadhyay?
My lord, I am coming, my lord.
Or Mr. Thakur, you can also. Which page of the
Lordship,
affidavit?
kindly come to page 8, internal page 8 of the affidavit in opposition filed by the state.
Yes.
My lord,
এখান থেকেই বলুন, এখান থেকেই বলুন।
No, the actual order must be annexed.
It is quoted.
আচ্ছা জজ সাহেব যেটা বলবে সেটা বলবো না আমি যেটা বলবো।
পুরোটাই পড়ে দিন,
My lord,
file order শুনে যান।
28 March 1998, first order.
Yes.
Having heard the learned counsel for the party, in our view, proper relief which can be passed is to the effect that there will be stay of the operation of the impugned order of the division bench of the High Court, subject to the rider the status quo regarding possession on spot shall be maintained by both the sides. Next, my lord, 16 December 1999. Status quo regarding possession on spot shall be maintained by both sides in connection with the members of the petitioner Sangho, who are before High Court in the writ petition out of which the present proceedings arise. Second, third, my lord, 17th April 2000. Next page, my lord. We grant additional interim relief in continuation of our earlier order dated 16/12/1999 to the effect that if in the meantime any vesting orders have been passed in respect of the lands of members of the petitioner Sangho who are before the High Court in the matter out of which the present proceedings arise, then those vesting orders shall not be implemented until further orders. Thereafter, my lord, 24th November 2003, on a careful consideration of the respective submission of the learned counsel appearing on either side, we are of the view that the authorities of the states shall ensure, notwithstanding the vesting order that may be effected in the revenue records, no third-party rights should be created, and no such third parties be inducted or allowed to enter upon or squat on such properties pending disposal of the appeals. They are
Mr.
placing
Thakur,
that.
one thing, otherwise you are right. Mutation does not create title. No. But doesn't mutation create rights? Otherwise, why are you insisting upon a mutation in the first place? Why do you require a mutation? You wouldn't require a mutation.
Mutation requires, my lord.
It
One thing.
Yes, you say that?
My lord.
Why is it required?
Latest judgment of the Supreme Court.
No, you tell us. Forget the latest judgment.
Mutation.
Why do you require the mutation?
The purpose of mutation is only to generate revenue of the state government. First point.
What is your interest in generating revenue of the state government? You are a private party. Let the state
My
for themselves.
my right is being affected because of the fact, unless the mutation is being done, we cannot put the tax to the state government. First, second
State
point
government is willing to waive that by not mutating. So let them.
They have not waited. They are straightway rejected without initiating any
What right
proceeding.
would you have if there is a mutation?
Without initiating any proceedings, without giving any notice, BLRO whimsically and arbitrarily rejected my application.
That is a different ground. We are asking
Second,
you,
my lord,
how would mutation help you? You have applied for mutation. State has not applied.
my lord, so far the ownership is concerned of the property, mutation is very much required.
Why?
For
what?
other purposes.
How will it help you? What purposes?
For before, my lord, we, the cooperative society, we bank upon the bank loan. Even the state government.
So for taking every act on the basis of your ownership, you require that mutation.
Not only, my lord, deed is sufficient to produce before the bank for taking loan.
Therefore, you need a mutation.
Mutation certificate.
Mutation certificate is
and
required.
tax receipt is there.
So therefore, Mr. Thakur, mutation certificate is required to assert your ownership in respect of the property.
My lord.
Before all forums.
Right.
Be it a bank or taking a further loan or whatever. So this assertion of your ownership rights is itself a right which is created by mutation. Supreme Court has not said no third party title will be created. No third party rights will be created. Therefore, how can mutation be given in the teeth of the Supreme Court, or all of us will be guilty of contempt?
I am citing decision of the Honorable Supreme Court so far mutation is concerned, my lord.
No, what is the proposition there?
Proposition is, my lord.
We are saying that third party rights, no title is created by mutation.
Revenue records, mutation name in the revenue records effect cannot amount to relinquish or right or title to others.
Exactly.
Right. Lordship.
It's not a creation of a right or
if
title
the
to others.
mutation is being done, the right of the parties cannot extinguish. Title of the parties cannot extinguish.
Title is different.
Right is different, no doubt.
Rights are of a much lesser. My ownership is a bundle of rights.
My title has been determined by the civil court.
Exactly.
There is no dispute.
Civil, no dispute.
Not only that, my sale deed has not been challenged by any of the party. The state government.
Wouldn't it be very risky for them or us even to direct this mutation to be effective in the teeth of the Supreme Court order?
It is practical difficulties for running the business of the cooperative society. It is 3,000 members, my lord. All fishermen have been suffering. Only one fisherman cooperative is existing in Dinajpur.
And you are a fisherman's cooperative also.
Fisherman cooperative, nothing more. Even state government, my lord, it is a judgment in the civil court. It has been reflected. State government funded 21 lakhs for rearing fish and development of the water body. If your lordship allow me, I can cite that findings of the learned civil judge.
No, the prejudice is very obvious.
My lord, that is my submission. It is my humble submission before your lordship. The mutation is very much required. And very thing, my lord, the matter is pending before the constitution bench.
Yes.
5 judges bench, then 9 judges bench. Now, when the matter will be finally heard, we know. Last 25 years.
So for that, that is a bad ground. We'll tell Mr. Kodwara that's
pending, my lord. 30 years.
Otherwise, no matter, because Supreme Court in some judgments has observed that mere pendency of a matter before the Supreme Court cannot be a ground for shirking your duty. The courts cannot shirk their duty.
My lord,
So that has been held by the Supreme Court also, and which is quite proper. There are so many litigations pending for years. Just due to pendency, we cannot hold
the
our hands.
pendency of the matter before the Supreme Court,
No, that
my mutation can be withheld. It is not a ground.
No,
my
we
lord.
are only
And not
bothered
on-
about this interim order. Whether
And not only that, my lord, we are not the deity is not the members before the Supreme Court. Only Sebais are the file and application before the Supreme Court. There is a gulf of difference between, my lord, your lordship know very well, my lord, there is a gulf of difference between deity and the Sebais. The property absolutely renunciated in favor of the deity. Sebais have no right over the property. Sebais are the members of the
Bhumijivi
Sangha. That is my contention, my lord. I am not asking anything which is prejudice to a state government, my lord. It is a state-sponsored cooperative society. It is a big cooperative society for rearing fish, my lord. All over Uttar Dinajpur, it is only one cooperative society. That is why, my lord, I am praying.
prejudice is too much.
Too much, my lord. I am praying.
Yes, Mr. Bandha, what do you say?
Well, the petitioner's case is this, my lord.
Your main pivot is this order of the Supreme Court, restraint order.
One by one, my lord, coming, my lord. They have not placed before your lordship, my lord. But the petitioner, my lord, purchased a bill, namely Raigachi bill. They have stated in paragraph number 3 of the
bill, whatever
bill.
they say. Yes.
My area of 24 point. Sorry, my lord. 45.99 acres. They have purchased 45.99 acres.
All right.
Of, my lord, the bill, namely Raigachi bill, my lord, they have purchased in the year of 1999. Date, my lord, 18th March 1999.
We have annexed the purchase deed, my lord. My learned friend has
disputed,
said suppression. We have not.
No, he has not come with a suppression as he. This is on the disclosure.
My lord.
Let us see. We are eagerly waiting to know what you have suppressed. Yes.
They have purchased the, my lord, said bill from the power of attorney holder.
Mr. Bandhavadi, we are seriously thinking that we should permit you to sit and argue because of the height problem.
Well, this was the problem.
The mics can never reach you.
Yes, we don't.
Anyway, yes.
Well, they have purchased the said bill on 18th March 1999 from power of attorney holder, that is one Mr. Kalipodo Sen, who is the power of attorney holder of the original owner, that is the intermediary, Atish Chandra Sinha and others. They are the members of the, my lord, the Bhumijivi Sangha.
Who are the members? Sebaites.
They are the Sebaites. They are the members of the Paschim.
But the DT was the owner.
My lord. My lord, previously, my lord, the Atish Chandra Sinha and others, my lord, moved one original application before the Honorable Tribunal.
Atish Chandra Sinha was who? The author of the trust?
Yes, my lord. They are the Sebaites.
Oh, they are the Sebaites.
Atish Chandra Sinha and others. My lord, your lordship, kindly take up my opposition, page 50.
Page?
Page 50.
Yes.
My lord, they have filed, my lord, here the, my lord, Atish Chandra Sinha and others. Way number 2437 of 2000, LRTT.
Yes.
My lord, I am reading. Order dated 12th February 2001. The learned advocate for the applicants and the learned government representatives are present. This application has been filed challenging the combined notices issued almost all the provisions of the West Bengal Land Reforms Act 1955. We are therefore unable to find out that precisely the revenue officer proposes to do in the proceedings in connection with which the notice has been issued. We therefore quash and notice the said notice and also the proceedings. It has been submitted by the learned advocate of the applicants that the DT holds lands falling within the jurisdiction of many districts. It is desirable that when the determination of the question whether the said duty is of a public nature of or a private nature under section 14T6 of the Act is not, it is desirable that there should be only one proceeding covering all the lands. Since the major portion of the lands fall within the jurisdiction of the district of Malda, it will be appropriate if the proceeding is initiated by the authority of Malda district. Accordingly, we direct the authorities in the district of Malda to initiate fresh proceedings, taking into account all the lands held by the DT all over the state, and determine afresh under section 14T6 of the Act if the debitor is a public or private nature.
No, this is the impugned order. No.
No, my lord, this is not it. It is a previous. My impugned order, my lord, your lordship, kindly
Yes.
take up, my lord, last portion, my lord, page
53.
53. My lord, reading. Then it will be clear, my lord.
Ah.
By filing this instant way, 54 minutes. It starts on page 54.
54 is the tribunal's order.
No, page 54 minute judgment.
54 is the tribunal's
Of my
judgment.
opposition, my lord. Of my opposition, page 54.
No,
My lord,
54 is the tribunal's judgment.
tribunal judgment.
No, we are saying the previous, the rejection.
That is, my lord, there.
That is at page 53.
Page 53, no, my lord. I am reading my page 50. That is erstwhile and intermediate.
No, where is the order which was immediately under challenge? The inaction.
That is page 54. That is under challenge.
What is page 53 then?
No.
What is page 53?
My lord, after my lord 264, the impugned order of the tribunal.
No.
What is it? 54 আমার opposition লেখা আছে। My lord, that is under challenge.
Acha, very good. Yes.
R4.
Yes.
Judgment, my lord, application dated, my lord, 22nd March 2024. But
Yes.
the judgment delivered. In way number 2332 of 2020. That is under challenge in this instant writ petition, my lord. By my lord, I'm reading. By filing this way, the applicant has prayed for a direction upon the BLL or Itahar, North Dinajpur, to mutate the name of the applicant in the current record of right.
Mr. Bandavata will start from this impugned order tomorrow.
My lord.
So it's a landmark from where we will start.
My lord.
Lordship, I am seeking a lordship's leave to mention item
Let
47.
us pass this order first. Hard in part for further hearing on September 1, 2020.
My lord, 1st September, I have fixed another matter.
Acha, September 2, 2025.
I am deeply obliged. my lord.
Yes.
Lordship, I am seeking your lordship's leave to mention item 47 of today's list. Lordship, we wish to withdraw this appeal as the matter has become infructuous.
47?
Yes, your lordship.
We don't have division bench tomorrow, so we'll put it as to be mentioned on Monday.
Okay.
So that you can withdraw. Hey, on 47.
Yes, lordship.
Please just write on a slip of paper and hand over to our
Okay.
to be mentioned and give the item number 47 and the cost type.
Okay, sure.
So that something will be on record.
Grateful, your lordship.
But for non-prosecution. For non-prosecution. To be mentioned for non-prosecution.
সোমবার